Because I was supposed to have my son today to pick him up from school.
I was calling to try to find out if she was going to be actually picking him up that day.
Because I've had job interviews.
Why is it happening?
Because George is dead.
I finally answered, and that's...
His ex-wife, when I say a monster, she's a monster. His ex-wife is bonkers about money. Well, it's not fair. It's not fair. Send me money, send me money, send me money. This is what happened. It's not fair. How can I send you money when I don't have a job? See, that is just not fair.
They'll use a phone.
How long will that take? Because I need to talk to Brian. I need to talk to Brian.
Welcome back. Today we are continuing our breaking down the 9-hour video coverage of the family trial into smaller, more manageable chunks. You know, instead of 9 hours, it's more like 3 hours. Last video we looked just at Sarah's cross-examination of Brian after his testimony, and now we're going to look at Sarah's testimony, including Brian's lawyer questioning her, and then Sarah's case in chief. It is truly a disaster because up until this moment, other people have been guiding her here and there. Her cross-examination was a mess, but at least she was aiming it towards Brian and trying to ask questions related to Brian. When she gets to her open case in chief, it is a free-for-all. So this is just a little director's cut edition. It will 90% be exactly what you saw in the 9-hour video with some little additions here and there from future me. I forgot to do this in the last video and there was some confusion, so let's make my warnings very clear. To begin, if this is the first time you're at my channel, welcome to the world of long-form rant content where there is no structure or goal other than me reacting to whatever I want to react to, and the video is finished when it is finished. I assert no authority on this channel. These are just my opinions. You take what you take, you leave what you leave. But if you leave a like on the way out. That's just good home training. I talk a lot, so if this is a video where you want to see this played all the way through, this is not the video for you. I think I'm going to put a link in the description to the full family court trial with no commentary so that you can check that out, all compiled by Human Tooth. I forgot to give you that shout out last video. Thank you again for putting this together and allowing us to react to the chaos. And with that said, let's dive right back in.
Miss Boone, are you there?
I'm here, Your Honor.
Okay. All right. I don't know if I may have accidentally hit mute again. We just located your exhibit that was entered into evidence as Exhibit 1. The clerk now has that. Before we took a break, petitioner's counsel indicated he did not have any additional questions for Mr. Boone. So now I turn back to petitioner's side and ask, do you have any additional witnesses or evidence you would like the court to consider?
I would call Miss Boone very briefly.
Oh, here we go. Now we're moving on from her asking the questions to now she is the witness being asked questions. This is going to be a mess, but I want her to keep her own words in mind during this questioning. Remember, most of my questions, it's just a simple yes or no.
In the jail. Yes, no. For most of my questions, it's just a simple yes or no.
I can guarantee most of these questions will be simple in what they're asking, and she's going to make them the most complicated things imaginable. Please do not let this go on for too long. Linda is also begging that you just answer the question so we can move on and to not go around in circles as we know you're about to do.
All right, Mrs. Boone, counsel has some questions for you. And once he is done, what I'll probably do is I'll ask you, do you have anything that you want the court to know right away based on the questions that he has? And then we'll get and see if he has any additional witnesses and evidence, and then I'll turn it over to you for your presentation, okay?
Yes, Your Honor.
All right, you may inquire.
Thank you, Your Honor. Ms. Boone, you filed a financial affidavit in this case on May 30th, 2025. Is that correct?
One moment, please, and I'll pull it.
I'm just imagining she's sitting at a table and there's just a mess of papers spread out all over the place, and she's frantically looking because there's no organization.
Go ahead with your question while I'm looking for it.
Well, I want you to locate it first because I want to ask specific questions about specific pages. So I'll wait for you to locate it. Did you receive the exhibits that we sent you? Because it also would be in that packet as well.
I have it located.
Okay. And that financial affidavit that you've located, that has a stamp on the top of it that says that it was filed at 1:08 p.m. on May 30th, 2025. Is that correct?
Yes.
Okay. At this time, Your Honor, I'd like to submit what has been previously marked as Petitioner's Exhibit E, which is the respondent's financial affidavit filed on May 30th, 2025, into evidence.
Any objections to the court considering your financial affidavit that was filed May 30th, 2025, Ms. Boone?
No, Your Honor.
All right, hearing no objection, I'll receive into evidence what was pre-marked as E as petitioner's number 3.
Okay, ma'am, I just wanted to ask you a few questions about your affidavit. And I want to just laser focus right in on your expenses section, which starts on your page 6 of the document, and for the court's following of my exhibit, bait stamp page 46. Let me know when you're there, Ms. Boone.
I'm there.
Okay. So this section here is going through what you estimate to be your expenses. The first question I had for you is, have these expenses changed dramatically since you started your incarceration in February of 2020?
They haven't changed because they've never started.
Hold on, pause this shit. What the fuck is going on in here on this day?
It's just an estimate from going off of the canteen list.
Oh, absolutely not. What? You put estimates on your sworn financial affidavit. What did you think that was? This is supposed to be your literal payments, what you've actually paid out of your pocket for these expenses, trying to justify your need for alimony. And you're just saying, I'm putting estimates based off of what's in the canteen. Well, what have you gotten from there? This isn't a what ifs possibility financial affidavit. This is you saying, these are my monthly expenses that just so coincidentally add up to be $1,000 while I'm still in prison and have all of my things provided for me. Wow. Straight out the gate. What's your first response? Well, I lied about this because I don't actually pay all of these things. And you can have some estimation, but it needs to be relevant and your actual monthly needs. Saying I need 6 blocks of cheese and some cookies for my blood sugar and cancer is one thing if you're estimating based off of the prices. Normally I get this every month and that costs blank. Not, I would like to have all of these things, and if I got what I wanted in my dream imagination, then it would cost this much. So that's why I need this much money. Wow, not a great start.
Okay. So from February of 2020 until today, you have not actually incurred any of these expenses that you've listed on your financial affidavit. Is that correct?
You're asking me from when I was at Orange County?
Yes.
To the present day.
Yeah, I asked you the question about these expenses, and you said you mentioned something that you haven't actually incurred these expenses yet. So that's what I asked a follow-up question to that of, are you telling me that since you started your incarceration in Orange County in February of 2020 until today, have you actually not incurred any of these expenses that you've listed here on your financial affidavit?
What do you mean by incurred, please?
Really, Miss Walking Thesaurus? The woman who tries to use every single word in the dictionary, very haphazardly, and it barely fits the context. Over here, talking about arrearages, talking about in the text messages how you felt ensanguinated. This has to be said, and I cannot keep writing all these time-consuming and supply-exhausting letters. It takes days or weeks, and it's not like I can hit the delete button when I make a mistake. I have to start all over again. Every time, so as I don't get picked on or attacked for something else. Sorry about that. The letter I sent yesterday was only 4 pages. I exhausted 4 cheap-ass jail pens and 15 sheets of paper. Imagine what all it took for the 58-page letter. And the other one I'm working on. No one understands mentally, physically, emotionally exsanguinated. Or the literal bleeding out after being made to go pro se. And you even told Lana in one message, like, you're so smart because you use big words and I can relate to that. I hope, too, it doesn't scare you off or make you uncomfortable with the contents. I trust you, Lana, and do not believe you would do anything deceitful to hurt or expose my contact with you. You're really smart and use big, appropriate, professional words, and I relate to you 1000%. Oh, you're really smart because you use big words, and I relate to you 1000%. That's her judgment of intelligence. I mean, but that explains why she thinks that she could overwhelm George, because George's vocabulary just wasn't as expansive as hers, at least in English. I still don't know. I think he did speak Spanish, but I don't want to be offensive. But if he did speak Spanish, then he knew double the words that you knew. And that's why I've never understood specifically in America, the stigma against bilingual people who have an accent or broken English. I'm like, that's like having 2 keyboards running at the same time in different languages. But you don't know what incurred means? But you know what? I won't hold you to it. Sometimes we just don't know some words, but context clues should easily tell you what he means. But you know what? I'll have Camille Vasquez step in real quick and let her explain it.
As of today, you have not paid
$1,000
of your own money to the
Lowell Correctional Facility.
yes or no. So as of today, you have not paid
$1,000.
right?
Have you had to pay them?
Have I had to pay for food? Yes, I have.
Okay. So, has it stayed though? My first question to you though, in which you answered it in a different way, so I want to answer it again. Ask you again is, for example, you have here on your financial affidavit that you filed in 2025 that your food expense is $250. My question is, has that number gone dramatically up or gone dramatically down, or has it stayed relatively the same since you started your incarceration in February of 2020?
I don't know or remember in regards to my incarceration 5 years ago, but I know for the current time, this is just an estimate because the prices fluctuate. So as of right now, it's about the same.
Okay. Now, does the facility that you're incarcerated in, does it provide you meals for free?
It does.
Okay. Does it provide you breakfast, lunch, and dinner for free?
Yes.
Does it provide you any other meal times other than those 3 times for free? Snack times or anything like that?
No.
Okay. Does it provide you things to drink for free?
Water, yes.
Okay. So when you indicate here that you have an estimated food expense as of May of 2025 of $250, what is that for?
That is for my low blood sugar, which the petitioner is aware that I have had ongoing, and need to maintain my blood sugar. My grandfather died of diabetes, and I have to maintain that with snacks and in between meals. Some of the meals are, of course, unappetizing, and my stomach is not able to handle them properly, so I either do without or would fall back on something that I could order or purchase from canteen.
Oh, girl, goodbye. Get out of here with all of that. You put $250 a month for your blood sugar. Just say you don't want it. Just say, I want to have my big activities so I cannot eat this nasty prison food.
Hey,
Security heavy.
Let me enjoy some stuff. At least that would sound more honest than it's for my blood sugar. Even though I have no formal diabetes diagnosis, you know, we do have nurses and medical care facilities there, access to medical care. This is all preference. She let it slip in the middle. She let it slip and she tried to cover it up. She said, well, obviously.
Some of the meals are, of course, unappetizing, and my stomach is not able to handle them properly.
Security heavy.
Some of the meals are obviously unappetizing and my stomach is unable to handle them properly. What does that mean? This is all speculation. This is not like actual need. Courts look at the actual facts of the situation, not your preferences. If you did have diabetes because a health professional was tracking your blood sugar with you and you had plans and you had needs and necessities, then that is something the court can consider. You saying this shit is nasty, so I want something from the commissary is not going to cut it. I don't know if she knows how bad this is.
And are you actually incurring this expense in purchasing additional food above and beyond what the prison is offering you for free?
I have from contributions, yes, but on a regular basis, no.
Okay. Explain to me these contributions. What are you talking about when you say from contributions?
I have a friend that will deposit money in my account on a rare instance when she has an extra or something spare.
Okay. Do you have any other contributors?
My brother, when he's able to.
Then why did you leave that out? He just asked about these contributions and you just said there's one individual. So sorry to everyone who's been donating her things. I know there's a long list of people who have sent donations, hundreds if not thousands of dollars of donations to her over the years. But that got diluted down to one individual. Is that Christina? Christina?
Christina! Christina's gone. Your little tramp didn't leave any money to pay her, so she left. Just like a little slut.
Congratulations, Christina.
Christina!
You got yourself a shout out. And sometimes if she's able, when she has excess, who just sits there and has excess money? Actually, don't answer that. I'll feel poor. And then he asks, well, are there any other contributors? Yeah, my brother. Well, does he need to keep asking for you to tell the rest? Your brother, you mean your family member, part of the family that's dead? So you do have familial contributions that help you, but not your son? Got it.
So if I understand you correctly, this food expense is not for breakfast, lunch, or dinner. It is for supplemental food that you believe is appropriate due to your blood sugar. Is that accurate?
Yes, and also in regards to the meals not being able to be digested properly.
Okay.
Yes, Mr. Martell, that MK was loud. Because it's ridiculous. She keeps trying to double and triple down to make this sound like this big blown up issue.
Security heavy, like she could protect the building type big.
The more she tries to clean it up, the worse it looks.
Okay.
Primarily for medical reasons.
Okay. And then you have on here another charge of $100, or another expense of $100 for gifts for holidays. Is this for gifts for your son?
Yes, that's under child expenses.
And is this $100, are you asking that Mr. Boone pay you this so that you can give gifts to your son?
Would he be paying the alimony arrearages or a dollar amount? Yes, I would like to have that deducted from that dollar amount because I don't have income on a regular basis.
Okay. So you want your husband to give you alimony so that you can...
Ex-husband.
You're right, excuse me. You want your ex-husband to continue to give you alimony so that you can then turn around and purchase gifts for your son on your behalf because you cannot purchase those gifts because you're incarcerated. Is that correct?
My alimony payment can be spent however I make or decide how to do so. And yes, I would like to include my son for gifts on holidays or just because I love him. Yes, that would be a part of my disbursement of my alimony.
Another terrible answer. The mask is slipping, Sarah. I don't know if you know this. The mask is slipping. I mean, it's already slipped off, but this is who you truly are. You're not trying to get this money for any other reason than you think you're entitled to it. The question was, you put down stuff for child expenses you do not cover regularly, if at all, ever. But you just put that down because you need the dollar amount to be higher. And so he asks, would that be coming out of the alimony that you would then go around and ask him to use that money to pay for these gifts to give to your son? Like I've said plenty of times, his money goes in a circle and it makes no sense. And then she reveals, would that be my alimony? Yes, I want my alimony, and then I also want to include my son, for gifts and holidays and when I want to. Okay, but you put down child expenses. Brian has actual child expenses: food, water, clothing, shelter, general happiness, all of it. Those are actual expenses, not hypothetical, well, if I had the money, I might buy my son gifts for no reason just because I love him. Doesn't that make me such a good parent? No, it doesn't. And it reveals exactly who you are. That would be up to me, my alimony. You realize you are talking to a judge who is going to decide if you deserve any alimony whatsoever, ever since you were incarcerated. And every time you are so combative and you double and triple down and you act so entitled, you show everyone exactly why you deserve to be where you are.
Do you think it's fair for Mr. Boone to give you money to purchase gifts for your son that you can't afford to purchase because you're in jail? You think that's fair to him?
Alimony is court order, which is unfair that I have to not be paid what I could have been paid.
Yet again, deflecting from the actual question, the question is it fair for the father of your child who has sole custody and is responsible for paying for everything in his life, is it fair for him to give you more money so that you can then go around and buy gifts that you can't do on your own because you murdered someone and put yourself behind bars for life?
To life in the Department of Corrections.
And how does she answer that? She says, alimony is court ordered, and it's unfair to me.
Okay, well, it's not fair. It's not fair. It's not fair that you guys, just because he has those, automatically blame it on me. And it's not fair. That's not really fair.
How many, you had 2 neighbors you went to and asked to go to the restroom.
See, that is just not fair.
Hold on.
It's wrong and it's unfair.
You certainly entitled to that opinion.
That I should have been paid, and I could have been paid, and I wasn't, and where's my money? Me. These are amazing answers for Brian's lawyers, just incredible. You couldn't ask for more. You couldn't ask for a deadbeat parent to show just how deadbeat they are than this.
Okay. You also have on here that you have a $200 communication charge. Is that for the phone calls that we've been talking about?
That's for all of the communication opportunities that have not been taken advantage of by the petitioner. It's not just phone calls. It's video visits, it's videograms, it's cards, it's a multitudinous amount of technology that is available to be utilized if decided to.
Okay, if decided to, who cares? Again, this is on your sworn financial affidavit as costs you have incurred. You are saying monthly, I spend $200 on communication, even though I just spent a whole hour arguing that it's only 13 cents a minute and that it's so cheap and that how on earth could you not give me all this if it costs almost nothing? How are you spending $200 worth of communication expenses? $200, you have 13 cents a call. Let's just say round to, Brian said it's around $5 each half-hour call. That's around, what, 20 hours? 40 phone calls talking on the phone to equal $200? Or if you're doing text messages at 50 cents, that'd be 400 text messages. No one ever needs that much communication. And sure, you might have the videogram and the whatever card and the video visit. I'm sure they do not cost maybe like $10, $15 max. I don't know what this videogram is she's talking about, but this is just absurd. Your whole financial affidavit is a joke, yet you're trying to hold Brian as though he were under oath lying to the court saying, oh my goodness, how could he not be telling the truth? Meanwhile, you have not spoken a single truth this entire hearing. And then it's the contradiction because she claimed like $0 on everything. She makes nothing all year. That's why she needs the alimony, but also she pays this much every single month. How does that make sense? It doesn't.
Every effort, every expense that's been occurred. Oh, I'm sorry. You want to finish your point?
No, I was just stating that it is located in my exhibit, so you all are aware of the opportunities.
Okay. All right.
In the cost.
Okay. I want to be clear, though. Every expense related to you communicating with your son since you've been incarcerated, Mr. Boone has paid for that. Is that correct?
It's my only form of ability
Ma'am,
right now.
answer
Yes.
the question. Has what your communications with the child been paid for by Mr. Boone since you've been incarcerated?
Yes.
See, now was that so hard? I want to remind you of your own words real quick.
For most of my questions, it's just a simple yes or no.
It's just a simple yes or no. It's so funny because it's the literal exact question that she gave that answer, because she was trying to say, well, didn't you accept the 13 cents a minute?
When you originally signed up for this account in order to utilize the phone option, were you aware of the 13 cents per minute?
Yes. I have to pay for all the phone calls.
So you accepted the fact that it was 13 cents per minute.
You don't have a choice. That's the only way to have phone calls in the jail.
Yes or no. For most of my questions, it's just a simple yes or no.
Didn't you know that? And he tried to explain, well, it's the only way you can have a call. And you say, it's just a simple yes or no. It's just a simple yes or no. And then he goes, have you paid for any of those calls or any communications whatsoever? Well, it's just a simple yes or no.
I want to be clear, though. Every expense related to you communicating with your son since you've been incarcerated, Mr. Boone has paid for that. Is that correct?
It's my only form of ability. For most of my questions, it's just a simple yes or no.
Ma'am,
Right now,
answer
yes.
the question.
Oh, her life mirrors herself in the most beautiful irony there is. And by beautiful, I mean appropriate and deserved.
Okay.
Right, next question.
You have a $50 charge here for clothing. Does your prison provide you with clothing?
Yes, the prison
Okay.
provides uniform.
Then why did you put a $50 charge per month on your financial affidavit? As though you're telling the court you spend $50 a month on clothing. When they provide uniforms and you have no other options. Unless you're buying thermals and socks, underwear, whatever, this and that, you do not need $50 a month just for that. And if that is what you're spending it on, you needed to articulate that. But just another hole poked in this financial affidavit. She has zero clue how truly damaging this is to her whole case.
Okay. And then you have $15 here for medical and dental. Does the prison offer you any medical services?
You have to have a lien against your account. To make a sick call, you have to pay for that. For dental, you have to pay for that. Regardless if you have an insurance plan or not, you still have a lien placed against your account.
Okay. And you are estimating that your cost for that is $15 a month on your financial affidavit. Is that correct?
Yes.
Okay. And then you have here other hygiene and writing items. Does the prison provide you with basic hygiene items?
No. The prison only supplies I believe, 1.5 ounce all-in-one shampoo and body wash, toothbrush, and toothpaste.
Okay. Those would be considered hygiene items, correct? Oh.
Yes.
Okay. And you have here a $50 charge for creditor Department of Corrections. Are you indicating that you owe the Department of Corrections money?
These are all estimates. And you need to please remember that I am new to DOC and don't understand, but I do know that weekly draws from everyone's account every week. So depending on how much money you have in your account is how much they deduct from your account. This was just an estimate. I'm not even sure how they go by what they do, but this was what I was told to do from one of the classifications officers.
Oh, okay. I see. It's the classification officer's fault that you lied up and down this whole financial affidavit, and none of it makes sense. Got it. Always have to pass the blame to someone else because it just doesn't make sense. You should have just put 0 for half these things and then argued I still need to because there's all these other whatever. I don't know. You should have just been nice and tried to mediate to begin with and not be so difficult and try to control everything, because then you would still get something, and now you are 100% going to have everything taken away from you because lie after lie after lie just unravels. And then you get backed into a corner. And you all need to understand that I'm still new here at DOC. We're in August, 8 months. And you were convicted in December, so 8-9 months. That's still new? You don't know your monthly expenses after 9 months? These are just estimates. They're very high estimates at that. And then the only reasonable estimate you put down was for health care, and you put down $15. Well, I'm sorry, if you have all these diabetes, glucose, blood sugar, cancer diagnosis, all of these issues, you would think that would be the one that's more than $15 and why you need all this extra because I have to pay for all blood sugar cookies. She was really not prepared for any of this.
And a lot of these that we see at the bottom, it states estimates for all. The clothing is charged quarterly. It's not every month. And there's limited quantities, and also the prices fluctuate, which is why I included those as my exhibit so you all would understand the most current pricing.
Other than receiving contributions from third parties and receiving money from Mr. Boone, since you've been incarcerated, have you had to pay any money out of your own pocket to meet your day-to-day needs while you have been incarcerated?
Sir, I have no money.
I'm sorry, I didn't understand your answer. What did you say?
Insufficient funds. You ain't got no money. Woo.
Sir, I have no money.
You ain't got no money. Woo.
Okay. So the answer would be no, correct?
I have no way of doing so. No, I do not have any way of paying.
I have no further questions, sir.
And that is how you clear someone. After all of that, just culminating in how much of your own money have you paid out of all of this? All of these motions where you say you were owed this, that you've had this expense, you just admit, sir, I have no money. Meaning you were solely living off of Brian's alimony. This is just a money grab. Linda knows a money grab when she sees it too, and it's ridiculous. And you had no good reason, aside from the fact that you are poor, to fight this hard to get all of these resources from him, while still blaming him and trying to say that he is breaking all these rules. Wild. I'm just so glad we're done with this. Well, I want to be glad, but now we're about to move over to Sarah's case in chief, where she will finally be given a chance to present her case. She's been trying to do it this whole time. She has no idea what's happening, so she keeps trying to throw out every single argument she can in the inopportune and incorrect moments, in spots, in places, and times. But now is that time. This is the time where she needs to make all of her arguments and state very clearly why she deserves to still get paid, and it's court ordered is not going to cut it. So let's see if she can do it.
Get used to disappointment.
Ms. Boone, I will give you an opportunity to talk about the financial affidavit in just a minute, but I'm going to ask counsel any additional witnesses.
No, Your Honor, I just have some reserve a little bit of time for closing argument.
All right, any additional evidence?
No, Your Honor, just some demonstrative aids that I'll be arguing closing.
All right, Mrs. Boone, counsel has indicated that he has no additional witnesses or exhibits for this court to consider. I am now turning it over to you to present any evidence that you want this court to consider and any testimony you want this court to consider. And that includes any testimony or any explanation or additional testimony you want to provide to the court regarding your financial affidavit. Once you are done, counsel for petitioner will be able to ask you some cross-examination questions as well, okay?
Yes, Your Honor.
All right. And again, I'm going to say to you again, the topics we're here on today is the proposed parenting plan that was admitted into evidence as petitioner's exhibit number 1 that was pre-marked as G in the packet of materials that you received. as well as the request to have the alimony of $1,000 per month discontinued and the issue of child support of $100 per month discontinued and the request for attorney fees. Those are the only issues the court is considering today. Those are the only issues that you will be permitted to provide evidence on at this time. Okay?
Forgive me, it's Exhibit D, the proposed amended parenting plan, the attorney fees, and what was the last?
The request to discontinue alimony and the request to discontinue child support, which I think you said you agree that he should not be paying child support as of February of 2020.
Okay. So parenting plan, attorney fees, and alimony.
Correct.
Okay. So for the parenting plan, I would like please to put into evidence my number 2 and 3. I'm sorry. The parenting plan, the original one. My number 2.
All right, give me just a minute.
Where it's signed by those parties.
Counsel, do you have any objection to what Ms. Boone had pre-marked as Exhibit 2, which is the parenting plan that was filed with the court back on May 9th of 2018 coming into evidence? No, Your Honor. All right, hearing no objection, I'll receive us into evidence what was pre-marked as Respondent's Exhibit number 2 as Respondent's Exhibit number 2. All right, what was the second document?
The second document is the certificate of completion for the parenting and divorce class, number 3 and 4.
For the record, I have here what Respondent marked as 3. It is a parenting class certificate that was filed back on April 24th of 2018, and which is pre-marked as 4, is the parenting plan certificate filed back on May 15th of 2018. Any objection to Exhibits 3 and 4?
No.
All right, I'll receive into evidence what was pre-marked as 3 as Respondent's Exhibit number 3 and what was pre-marked as 4 as Respondent's Exhibit number 4. All right, what's next, Ms. Boone?
Am I allowed to explain those?
All right, I don't know that any explanation is necessary, but go ahead.
In regards to the parenting plan, first and foremost, I would like to state that one moment. From my parenting or from my pretrial statement, please, I would like to say that my incarceration has nothing to do with me as being a human being and a mother to my son. I've done everything I possibly can to be a part of his life, regardless. And
that's why you're in this position right now, because you still don't get it. You are saying my incarceration does not define me as a human and a mother to my son, as if you being incarcerated is the issue at hand. No, that is a consequence and an after effect of you murdering someone. You said that doesn't define you as a human being when you have taken another human being's life. That is the issue at hand. That is the true issue at hand. Because you did this, you isolated yourself from society and were locked up. You have then tried to deflect and make it symbolic, or I don't know, dilute it down to you're treating me like this because I'm incarcerated. And she could play that little game before trial because innocent until proven guilty. I didn't do it. It's unintentional, yada, yada, yada.
But not intentional. My intention was not intention. I didn't do it intentionally. That was not my intention. But my intention, intentional, intentionally. I intentionally did not do. Intentionally. Not intentionally. Intentionally. But my intent, intentionally, and not intentionally, intentional, intentional. I promise you, it was not intentional, which I swore on my son's life was not intentional.
But now that you have been convicted of murder,
We, the jury, find the defendant guilty of murder in the second degree.
that will always be part of the definition of Sarah Catherine Boone Paulsen.
Eating my peach.
You don't get to walk away from your actions like that. No. Sorry about it. Because I bet if you asked her, is your son a defining part of you as a human being and this and that? And she would say, of course he is. I'm his mother. That is basically her whole identity.
My son, where my son was located. My son, yes.
My son can't come over here because he's here. I want to see my son. I can have my son come over.
It's your house.
My son up.
That's fine.
And my 9-year-old.
Well, he's at school.
And that's what we're here to find out. We're just here to get the answer. The answers that you want, the answers that his family's going to want.
I just really want to see my son. I really need to see my son.
Everything else, I have no idea what it is. No idea what it is. Nonetheless, I've had my son over the house too, so why is it you all think that y'all don't know me, you don't know me, nope, would do something like that, especially having a 9-year-old son? I don't think you all understand who I am,
Okay. Well, tell me.
I mean, I've always been a straight-A student. I am an outstanding mother to my son.
Well, why is that? Because you gave him life. For you, that was a defining moment in your life. So what do you think happens when you take someone's life? Whether you want it to be or not, that is also a defining moment in your life. And because of that, everyone else's life has to change that was in your orbit or has to deal with you. And it's so annoying thinking back to when she said in the interrogation the day after, this has changed my life and I understand the severity of this. And he's like, he's dead. And she shouts, it's awful. It's awful.
See, and then it's all backfired on me. Like, it's all backfired on me. And I understand the severity of this.
He's dead.
It's awful, I know.
Okay.
It's awful.
As in, no duh, how could you remind me? Of course it's bad. Of course I understand the severity of this. No, you don't. 5 years later, and you still have no clue of the true severity of your actions. Because if you did, you wouldn't be shocked every 5 seconds when all of these things happen to you. But then no, also, because none of this made sense. She put in the exhibit of the parental parenting class certificate, the class she keeps talking about because she wants Brian to take it due to parental alienation and where he's not treating me right, he's doing all the wrong things, so you need to be taught a lesson, Brian, and you need to take this class. Whatever, right? So she accepts the exhibits and then she's like, well, am I allowed to explain them? You don't need to explain a certificate, but go ahead. Well, according to my pretrial statement, so you mean you're not actually explaining the exhibits, you're going off into a whole new tangent, which you could have gone off on anyway after they accepted the exhibits. But no, you said you have to elaborate on the exhibit by going the complete opposite direction. And then she had that stop-start of, first and foremost, I would like to give me a moment. And I've cut out a lot of spaces in between this because a lot of these times are uncomfortably long. I feel so bad for those who are in the courtroom because that must have been so cringe. Especially, it's kind of like I'm sure it was like a FBI, CIA torture because you never know when she's going to chime in. And it sounds like they have the volume cranked as loud as it can go. So I imagine it was just echoing in the whole room, and that's a lot. This whole thing is a lot.
I've done everything I possibly can to be a part of his life, regardless. And with the active parenting plan, my former husband has excluded me from my son's life in every way, shape, and form and alienated me, which is not part of the active parenting plan. So since 2020 of my incarceration to the present date without any modifications, he has followed the parenting plan in regards to trying to encourage the relationship as discourage the relationship. The point of my certificates of completion are to show the different topics that were covered in the court-ordered class that he had the understanding that he was supposed to abide by in regards to acting appropriate towards the other parents in front of the child, which he has not done. And the burden of proof is on the opposing party to show unfitness, and I shouldn't have to prove my worthiness. And I've done everything I possibly can in regards to be a part of my son's life. And as you heard the petitioner himself say, he doesn't care. He does not answer my phone calls. He does not answer my tablet messages. He does not respond to my letters. He's not made any attempt to find out any contact information. He's not done anything in regards to have me be a part of my son's life, and is now going from having me speak to my son on an almost regular basis down to one 30-minute phone call. I believe that is more detrimental to my son as opposed to helping him when I have had my parental rights intact since day one of my incarceration, and have helped my son since the day he has been born. And I don't believe that they should be terminated, or a 30-minute phone call should be viable, because no alternative exists. My parental rights should not be taken away. That could just be a last resort, and I don't know why he's doing it.
Why is this happening?
Because George is dead.
And I am used to him saying he doesn't care. And I believe that my rights should be preserved, and I have all of my case law stating such. So I don't know when I'm supposed to state that, or if this is my opportunity. I don't know what I'm supposed to do.
How many times do they have to explain this to you? I keep trying to let her spout off and play as much as I can, but we can never get any farther because it's just a mess. This is the time when you are supposed to make all your arguments. Everything that you have been objected to this whole time, everything she kept saying, stop talking about this, focus on asking Brian questions about what he testified and the reasons that we are here for today. We went through all of that. You got your ass handed to you on that questioning by Mr. Martell. Now we're here. Now it is open range. You can say whatever you want. And this is what you say. You haven't made any ground still. From the beginning of this trial, you have not made any ground for your side whatsoever. You keep trying to put the blame on Brian for absolutely everything, but at the same time admitting that he is the only one doing absolutely anything, which looks horrible for you saying all of this and all of that when you haven't contributed anything to the child or the relationship and trying to raise the child. And we know she's back to reading the pretrial statement because she goes to, quote, former husband, because she didn't say that earlier. She said ex-husband. But now that she's reading again, she had to remind herself, I choose these words intentionally when I write because I'm trying to add another layer of disrespect, not that it is a naturally occurring word that I default to. But she accuses him of alienated her in every way, shape, and form. And that is not a part of the active parenting plan. No definitions for any of this. What do you mean? Define these. He alienates you how? You have no examples because you alienated yourself when you got yourself arrested.
Why is this happening?
Because George is dead.
Brian is not the reason you are behind bars. You are. So he didn't do this. It cannot be parental alienation when your actions are what placed you where you are. Let's say you went down a noble path in life and alcohol didn't absolutely destroy any prospects you had at being a functional member of society, capable of contributing anything. And let's just say you were an astronaut, right? You were on NASA and they shot you to the moon and you wanted to talk to your son all day, every day. How is Brian alienating you when you decided to send your ass into outer space? While yes, this is a metaphor, the distance that you place between you and your son will always exist on some level, and that is not Brian's fault. And courts don't like hearing this all or nothing. It's fine when you're arguing in the real world, but we are dealing with facts, hard figures, and trying to make determinations based off reality. And when you say he's alienated me in every way, shape, and form, and you also admit he's paid for every single phone call and tablet message you've ever sent, that he's bought gifts on your behalf because you've instructed him to do so, then wrap them as though you did it yourself and give them to your son. Scheduling video visits, dealing with this, dealing with that, all of that means nothing when you say he has alienated you in every way, shape, and form. She doesn't give him credit for anything. And you're saying it's not part of the active parenting plan. Point it out. What parts? You just throw out wild accusations and say, well, I should win because I said those words. And what she'll say in the future is like, you didn't listen to me. You didn't listen to my heartfelt determination to be involved in my son's life. No, we heard you. You just said a crock of shit. And it didn't go anywhere. She's just cycling through the same things. Well, there is no modification. Yes, that's why we are here. You can't bring that up as an issue when we are here to resolve that issue. He should encourage rather than discourage the relationship, which is what he does not do. Again, no definitions. You're just saying these things. But you finally wrapped back around and you talked about the certificates you said you were going to talk about originally. And those certificates are to show the different topics covered in the class about acting appropriately to each other, which he does not do. Again, not defining. How about you tell me these topics? Topics on treating people appropriately as in blank, which he did not exhibit when he did blank. But no, you're just putting out these blanket accusations, and it's just the wolf crying wolf again.
I thought it was the boy crying wolf kind of thing.
If every single thing is cranked to the 11 and you are being so abused and mistreated and neglected and alienated and all this and all that, how come literal receipts prove the opposite? So then she keeps spiraling, being like, the burden of proof is on the other party to show unfitness. Yeah, and they have. 7 Ways to Sunday, they have shown how unfit of a parent you truly are. And they don't have to do anything. They literally said judicial notice of her court docket where she was proven guilty of murder.
We, the jury, find the defendant guilty of murder in the second degree.
In the second degree. That proves unfitness. There is nothing Brian could ever say or evidence he could show that would exemplify more unfit parenting than a murder trial. And she goes, I shouldn't have to prove my worthiness. Okay, cool, that's a cute idea, but you do have to prove your worthiness. You couldn't even prove your innocence. And now you want us just to assume your worthiness of all of this, the $1,000, the endless phone calls, and you keep warping what he's saying. You keep saying my parental rights are being taken away. They're not. This is not a motion to terminate your parental rights. It should be. They absolutely should have gone for it at this point. That's another reason why he's being so nice. He hasn't alienated you because he still wants you to be in contact. He is still going out of his way with his amended parenting plan to keep you involved in the child's life when he really doesn't have to. But then she admits that it struck a nerve. It hurts to hear the petitioner say he doesn't care, and I'm used to him saying he doesn't care. She has such a weird obsession with care, and she said this throughout her entire criminal process, all the letters. I highly doubt I'm going to look for them, but just trust me, it's there. But she talks about how the justice system and no one cares and no one's caring enough for her and treating her with care, as if anyone has to care about her. They don't. You chose not to care about George. Why do we have to care about you? He has not done anything to have me be a part of my son's life. We know that is false. You are speaking from a purely emotional stance. You want him punished, sanctioned because he made you feel bad. You want all the money because you feel like it's court ordered and you're entitled to it. You want all the time in the world because you feel like you deserve that and that your time would help your son be a better person, even though the father asserts that talking to you upsets him more than not. And you admit, yeah, that's a possibility, but it's because you allow him to curse on the phone. She's made so many backhand admissions that she has no idea. As if it's his job to make you an active parent. How is it his job to find out contact info for you? You are the one in jail. You should know your contact info by heart. You should be bombarding him. And we know you do that because we saw it with Philip that you put your address so many times when you think people have messed something up. Book ordered. What the fuck? Cancel the order you placed to have shipped to your house. I can only receive orders directly from the distributor and with a receipt. What was the reason? Are you positive it's soft cover, which is the only type I can receive? Do you have my address correct? Sarah Boone, 205623 FDC. Stop! I cannot receive the book from you. It has to come directly from the distributor. I sent you 2 messages telling you to cancel the order and place again to come from Amazon or wherever you're ordering. This is why I get so frustrated, and I know you are too. But there is criteria that has to be met or the entire order gets sent back. Soft cover only comes directly from distributor. A gift receipt or receipt must be included in the order. My info must be correct. Sarah Boone, don't waste money sending from you. Please, please, please reorder so I can finally get this book to get asshole Brian in court. He's withholding me money again for the 3rd week, and I have nothing. Please, Philip, I cannot take much more from him. My number is I forgot to add a 0 in my other message. And those were messages to Philip, her brother. So she has no problem whatsoever making sure everyone knows her contact info and the info she wants them to know. But she expects Brian to go out of his way to somehow figure out where this inmate's contact info is. You know, contact info he will never need because you are in prison and can't do anything. The only emergencies she can be involved in is being notified of something major happening. Not that there needs to be any decisions from her, any actions from her, anything from her, because that's not possible. So this whole argument is stupid to begin with. Of course you can't be involved in major decisions. And don't know where to send things. Why have you not bombarded him with your address? You said that you've sent him mail. So obviously he at least knows some address of where it came from. It just shows a sustained pattern of refusing to take any responsibility or accountability for her actions whatsoever. And I've had my parental rights intact since the day I was incarcerated. Yeah, because things don't happen instantly. You've had your case law. You're talking about all the case law you want to bring up, but there's case law out there that incarceration does not in and of itself inherently terminate parental rights. Great. That's why you have to go through a process like this to do it officially. And I've helped my son since the day he was born. Okay, congratulations. Do you want a cookie?
Security heavy.
I'm sorry, parenting is a very thankless job, and you don't get brownie points for not abandoning your son when he was first born. Congrats, glad you didn't, but it does not make you this saintly mother by simply harassing your child into loving you. And she keeps saying, like, I believe that would be more detrimental to the child than not, but she has no proof or any reason to back that up. Why? Why would that be detrimental? Well, because he needs his mom. I mean, she's not even saying that, but that's the inference. But you needed to provide reasonings for why you need to be in your son's life. I mean, you do the sunny Sunday scripture thing. You could have said, I'm needed in my child's life because I keep him close to his faith and I keep him, this and that. And Brian doesn't do this and doesn't take him to church. And so I bring this necessary aspect, something that, makes you stand out as a reasoning why talking to you is a positive, rather than the only evidence that you as well have agreed with, that he does not feel great after talking with you all the time. Okay, I'm rambling. Let's keep going.
The minor child is very aware of these ongoing hindrances and speaks about to the respondent and his desire to see her in person, which she also has been asking petitioner about almost on a daily basis. The minor child apologizes to the respondent regularly that the petitioner does not do and prolongs their overdue time together in person. The multiple children's rights he has violated in regard to developing an independent and meaningful relationship with each parent because of the petitioner. He is present during the parents' personal battles while I'm trying to speak to him on the phone. To speak ill will, he has called me murderer and killerer in front of my son, which is another reason why I wanted to have the guardian ad litem, which has been denied, I believe, 3 times. He doesn't include me in any way, shape, or form in regards to anything that has to do with my son's life. I know a lot about my son. I know what his favorite color is. I don't believe that petitioner even knows that much. The name of his girlfriend, the things that they're going through. I am part of his daily life, and for him to take that away from me is just out of bitterness and spite. I want to be a part of my son's life. And people forget that I have a pending appeal. So to prove my innocence, which is what I've been doing since day one, the reason why I was incarcerated in Orange County for over 5 years, or at least 5 years, was because I continued to fight for my case.
I lied to the police, basically everyone, because I was extremely fearful of being arrested. I made the first attempt of me calling 911 by telling them what happened, and I thought they were going to help me, but instead I was arrested for calling 911.
The reason why I was incarcerated in Orange County for over 5 years, or at least 5 years, was because I continued to fight for my case.
And I thought they were going to help me, but instead I was arrested for calling 911.
Yeah, that's literally what every criminal does before they are convicted. Everyone, quote, fights for their case. Oh my goodness, what? And she's just saying, because I was fighting, that means I'm innocent. That means I'm doing good things, even though a man is dead because of what you did.
And then it's all backfired on me. Like, it's all backfired on me. And I understand the severity of this.
He's dead.
It's awful, I know.
Okay.
It's awful.
And you want more than anything for everyone to just forget about it, and we won't do it. I just want to know, is anyone ever going to explain to her that that is not what an appeal is for? We've gone over this multiple times on the channel, but if you don't know what the appeal process is, appellate courts are normally a panel of 3 judges who review the case docket to see if the trial court made all the correct decisions. The appellate courts do not relitigate the actual case. The evidence is only consequential in terms of context, not in terms of validity. Because this evidence exists, did the judge make the right call, and whether it's admissible under certain contexts or whether this or whether that? That's what they're judging, not whether the evidence is accurate or not. And for some reason, she has this false belief in her head that the appeals court is just the trial court all over again. No. Let's say they side with her. Let's say they say, making her go pro se after going through 8 lawyers was just cruel and unusual punishment. She needed at least 20 lawyers before we actually considered taking them away from her. So you win your appeal. Congratulations. What does that mean? That means they send you right back down to Kranick again. And you rerun the trial all over again. In some instances, you can get a new judge if you want. That's not always guaranteed. But then you would just go through the exact same process again. And maybe instead of an 1.5-hour verdict, you can actually get them to deliberate for 2 hours. But at no point in that process are you proving your innocence, nor is release an option in your foreseeable future. I mean, forever, but even if you won the appeal, for an indefinite amount of time. And appeals also take years to go through. So she says she has a pending appeal, yet you will have a pending appeal for years, especially when you're on your 4th appellate attorney. Wow. So your pending appeal may be indefinite, and no one has time to wait for that, so we need to make these decisions right now. But yeah, if there are any friends of hers out there, please tell her her appeal will not set her free. But in terms of this chunk, she's just reading from the pretrial statement. The minor child apologizes to the respondent regularly. I mean, like, you're literally referring to yourself in the 3rd person as respondent, but whatever. Because the child knows everything that he does and is so apologetic because he can't believe what his father is doing to me. You are using that boy as a shield, and that is gross. Family court judges deal with this all the time. Like I say, she is the most stereotypical abuser that there has ever been. She checks all the boxes. Every time we enter a new realm of abuse and she happens to have crossed that realm and been made queen or high priestess or the patron saint of audacity to do the things that she does, she still finds a way to exemplify every single aspect of that abusive nature. And we are in the deadbeat parent realm, and she checks every single box again. This is I'm using the child as a shield in order to deflect my own inadequacies and my own issues and try to paint that on the other parent who is actually the one raising the child and being responsible. That way, as long as I make everyone else look bad and make you believe that they are bad, then that means I'm good, right? Forget the actions. I am solely focused on people's perceptions of me and not the reality and the facts of the situation. As if even if we bought the constructed perception you want to throw on us, that would not change the fact that you murdered someone and a jury of your peers found you guilty of murder.
Will the jury find the defendant guilty of murder in the 2nd degree?
You wanted to just say my criminal incarceration and criminal acts have nothing to do with this because this is family law. Your criminal conviction overrides all of this. So every time you keep saying he's parental alienation, he's called me murderer in front of the child, there's a difference, there's nuance. Has he told the child that you are a murderer, or has he told you you are a murderer and you assume the child is in the room at the time, thus overhearing you be called a murderer? Those things are different. Either way, he's absolutely in the clear because it is a truthful statement. You have been convicted and determined. You have been adjudged guilty.
She seems like
everyone else not to remember I am innocent until adjudged otherwise.
Guilty of murder in the second degree.
She treats me as if I am not.
Guilty of murder in the second degree.
So the disparagement clause, which is standard in most parenting plans, is not being violated by talking about a truthful situation. Yes, you're not supposed to disparage the other parent, but speaking true facts is not disparaging. It is trying to explain and talk about a difficult situation that the son has to come to terms with and has to cohabitate with in some way. That nebulous elephant in the room that follows him everywhere, she doesn't care. She thinks you should ride the elephant to her and then thank her for bringing you such a nice gift. And she does what she always does in her criminal court case of saying all my constitutional rights are violated. Same thing here. He's been violating all of these child rights, these children's rights of him to develop and have an equal shared relationship. You can never have an equal relationship because of your actions, not Brian's. Brian's inactions, as in his inability or lack of ability or lack of willingness to go above and beyond so that you feel just as involved as a parent, does not make him legally liable for any of this. It just shows your feelings are hurt and you wish things were different. But they aren't. And you bring up the guardian ad litem again, and you said, which I think was denied 3 times. Maybe take the hint. If it was denied 3 times, denied by your Honorable Judge Jackson.
Miss Jackson.
So it's like you're trying to scold her, saying all of these things, all of these very valid, true, legitimate issues are your fault because I tried to have a guardian ad litem in order to prove this. What does that mean? I wanted to get a guardian ad litem to use as a sword and have my son as the shield so that I could attack Brian and say, look how unfit he is. Look this, look that. This is what he's done. Failing to realize, because she doesn't think outside of her own benefits and her own thoughts, the damage that would do to her son. And that's why it was denied, because he doesn't need to be involved. Can you imagine if he were in that courtroom right now, listening to the way that she's been talking this whole time? No child needs to hear their parents going back and forth like that. Unfortunately, because of the virality of this case, he will see this at some point, but he didn't need to be in that room. And she tried her hardest to get him to be an equal third party in all this, to get the guardian ad litem to do this investigation. And do you know what this investigation would be, since she wants to get into the parental alienation? That guardian ad litem would have to go to the child and say, hey, has your father ever called your mother a murderer? And he can say yes or no. Let's say he says yes. He then goes, and how did that make you feel? Now the son has to connect with that word and is reintroduced to that traumatic experience, has to unpack what that meant to him, disclose that so that you can get the right answers that you want to show how much pain and suffering he puts your child through by calling you a murderer, ignoring the fact that you're a murderer.
Guilty of murder.
And it's those details that just shows she's centering herself, and the child's well-being is not actually in this picture, which is the whole reason you would have a guardian ad litem. Then the next deadbeat parent checkoff box is the, I know a lot about my son. I know his favorite color. Again, in her mind, when she was arrested and he was 9 years old, he has been 9 years old ever since. I know my 9-year-old's favorite color might sound more appropriate or not as weird as a 13-year-old or 14, 15, I don't know how old he is, as a teenager, and then has the audacity to say, I don't even know if the petitioner knows that. I know the name of his girlfriend. If you know these things, how on earth would Brian not know these things? You think that he hid the name of his girlfriend from his father, but waited to tell you. Someone who I'm sure hounded and twisted it out of him, because who's out here just giving out that information randomly? Well, I don't know, maybe. But it's so desperate because these are the same talking points she already brought up before, and Judge Jackson had to stop that and said, we're not doing this here.
Not on my watch.
The majority of the time, I will tell you this, which you are unaware of because
You're
you
not
do not
telling anybody anything, ma'am.
Not on my watch.
You're not telling anybody anything, ma'am. You're asking a specific question. Ask your question.
Because you're not going into the son's life to further use him to manipulate. It's tacky, it's overplayed, and it's as obvious as can be.
I know that the petitioner understands the reasons why of the include 30% time sharing because of the danger and safety. There's a lot of things that I was trying to protect my son from. I'm not that parent because I was trying to make sure he was safe and in a safe place.
Yeah, you're not a bad parent. You're a shit parent for putting him in that danger to begin with. That's just so insane. Again, if it's not your fault, it's Brian's fault. If it's not your fault, it's your son's fault. If it's not your fault, it's all the judge's fault. If it's not your fault, it's George, your murder victim's fault yet again. The true danger has always been you. It's because you wanted your son when you wanted your son. You want not to take custody of him to like actually do your job as a mother, as an outstanding mother, and care and raise your child. You wanted him when you wanted him. Brian mentioned how you would go over to his house instead of actually having him stay with you so that you can play house at Brian's house and all this and all that.
I mean, she told me like a week ago she had to escape from the house and wanted me to come pick her up. I told her I wasn't going to because I'm just tired of it happening. I mean, it was midnight. I mean, child's trying to sleep and just honestly, I don't always believe her when she said these things were going on. And
she called you?
Yeah. Okay. Yeah, and I mean, apparently she went back inside and slept well. Was in a fine mood the next day. I guess didn't really remember calling me, so I don't know if it was just
brought up again?
if it was just she wanted to come over to. I don't know. She keeps on trying to come over to like hang out or something like that, or she'll come over to spend time with. Rather than actually just having him over here like she's supposed to, but she wants to come over there and play with him. And so,
and then you get to go back to your little party mansion where y'all get drunk 24/7.
In excess. They didn't drink to drink. They drank to sunrise to sunset, all the time in between.
They were always drunk, like I was saying before, like always, like sun up to sun down type, like all the time.
They almost always seem either like tired or like tweaked out.
I do know that I have seen both of them intoxicated as early as 9 o'clock in the morning, and I mean staggering, falling down intoxicated, both of them. Sarah was actually wandering around the property very drunk, barefoot, not properly dressed, I'll say it like that.
And it strikes a nerve with her because she thinks, well, that's the excuse I've been writing for 7-8 years, that I'm only doing this and only not having him because of what George has done and because it's so dangerous. And George. She always has these default excuses, and now that her default excuses are literally dead, she's still spiraling because that's all she knows. All she knows how to do is blame others for her actions. A good mother wouldn't take her child and drive to go pick up her alleged abuser and then call Brian to come pick up her child because her alleged abuser is over and she can't have him over. And then every time Brian goes and picks him up, there's never really an issue. And it just so happens that as soon as your son's gone, your whole night gets better. And she always does this thing of the petitioner knows, and I know that they know the reason. Like she's done that multiple times where she just, again, pushes it on the other person of, I shouldn't even have to explain myself because I know that you know. So we all know that it doesn't even need to be said.
If I knew to be prepared, I know that everyone knows that I would be prepared, which I am unprepared because of.
That's certainly your opinion that you're entitled to.
My verbal statement is primarily to the Torres family, to the judge, to his daughters.
I know you all know who I really am and that I did care for George and that I do still love George.
I don't love you.
I know that everyone knows that I would be prepared. I know you all know who I really am.
I know that the petitioner understands the reasons why.
Constant and sustained danger he was under while he was over, even though everyone recounts that George was a happy drunk or an emotional drunk.
And then she starts arguing and telling him that, no, tell him what you've been doing to me, you choked me, this and that. But he was calm, and he was like, okay, I gotta let you go. And then he said, I love you, and then I told him I love you. And basically, that was it. So.
You said that he sounded calm?
He was calm, relaxed. Like he would. I can tell because my brother's been drinking for a long time. We tried to get him help before.
Right.
And I can tell when he was like really drunk, and he wasn't that drunk that night.
He wasn't.
So when you're describing him as calm, that's an indication that he hadn't been drinking that much.
That he wasn't that drunk. No.
Okay. When he's been drinking, does he get really excited?
Sometimes he gets excited, and you can tell he like slurs his words, and and I can tell like he gets really emotional, and sometimes starts crying and.
Okay.
So that's also sad. Like I said earlier, there's different types of drunks. There's the happy drunk. She is the angry drunk. He seems like the emotional drunk, which is just a very harsh contrast. If they were both angry drunks and they both kept amping each other up, it would make a little more sense why things get so violent. But it seems like they would both drink, they have their good moments, and then he gets emotional and sad, and she gets angry and violent. It's just kind of beating down on him more. We get happy or sad real quick. But what did everyone say? When you get drunk, you get violent, you get angry, you get abusive.
But I mean, she started just getting really angry when she drank a lot.
So you realize he's here now, right? So have you been drinking?
I had a drink.
Okay. Yeah, I have to. He's here. Yeah, you can stay right here. You can stay right here. He doesn't know that you call. He doesn't know how to play.
Babe!
Stop screaming at him. Go back inside.
Sure!
Go back inside. Jesus.
Do you need Jesus right now?
And call mom and pop.
How's Henry over there talking to him?
Why is this
What do you want me to do?
All right, go.
George!
And your actions track. So I'm still not buying this whole I couldn't take care of my son because my abuser had full control over me and I was just so helpless, and it just happened to line up with my own personal interest, and I had no issues bringing random strangers back home when I was still together with Brian and have them just shouting her name while their child is in that same house asleep.
The alcohol has gotten worse and worse and worse over the years. That's one of the main reasons why I divorced her. I just couldn't deal with it. I mean, it got to the point where, on weekdays she'd go out, and I guess the George person is one of the people she had met. Because I separated at one point and went over to my parents' house to live for a few months. And I guess she met him over at the pool place or something like that. But I'd come back and we were in therapy trying to work it out. And on a weeknight when he's got school the next day, I've got work the next day, she was out till 3 o'clock in the morning when the bar closes, and she'd bring people back over on the back porch. One time some random person walked in my house and started screaming for Sarah at 3:30, 4 o'clock in the morning when we're trying to sleep. I just couldn't get over it.
Not knowing these actual people's intentions. Great, you had fun at a bar and you want to keep the party going. Go to their house. Don't bring strangers to your literal child's home in the middle of the night, thus causing all this, because Brian said that was the straw that broke the camel's back of, I can't do this anymore. I can't get over this. The fact that you are bringing strangers. Cheating on me is one thing. We can work through this and we can just distance that. But when you bring your antics into the child's life, which is what you've done non-stop, then this is ridiculous and it needs to be cut off and your child needs to be protected. Meanwhile, A good parent doesn't introduce her child to the police after calling the police over a domestic dispute.
Who's this? Hi.
He wanted to meet you. You know, actually tell him what you want to be when you grow up.
You want to be a cop? Great job, man. Stay out of trouble.
Thank you. I'll call you later. Hi. But Dad,
That's your.
night, termite.
That's your son?
I love you, baby head. Yes.
Oh, with your ex-husband?
Yes.
Okay.
And even the officer is just like, you can feel the tension in his responses of, why am I talking to a child at 1 a.m. right now? Good parents don't do things like that, because the truth of the matter is that she felt trapped after having her child. That's what Brian said, and it tracks. In every one of her actions, she had her midlife crisis. She was a married wife, mother, 13 years, had a kid, and now that wild child has been contained, so she can't do all the things that she wants to do. Then she finds George, someone who's also in the throes of the same addiction as she is, and who tells her all the nice words that she wants to hear. So she gets to create her alcohol-induced delusional world when she gets to have her pawn son when she wants, and when she doesn't, she gets to call someone to take him away, and she gets to have her pawn boyfriend George when she wants, and when she doesn't want him, she has someone take him away, either his parents or the police. She thrived on controlling every aspect in her life. And when it all got taken away from her, she lost her mind.
It seemed to have gotten worse and worse. I think more or less kind of since we had. And I think a lot of it was the fact that she kind of, I guess, maybe felt trapped or something.
Okay.
That, I mean, before that, I mean, whenever she wanted, you're outside having a drink. Oh, I want to go play pool. You go over across the street, you play pool for a little bit.
Yeah.
That's not happening anymore when she got a kid.
Right.
So.
How old's your son?
He is 9. So, but I mean, she started just getting really angry when she drank a lot. She said last night she fell asleep. There were plenty of times where she just basically passed out from drinking. So,
you've witnessed her pass out from drinking.
Oh yeah.
I'm not that parent because I was trying to make sure he was safe and in a safe place. The time sharing, it's, of course, it makes no sense to have the realization one is not what we're talking about now. I do not feel that it is right for me to have a 30-minute phone call with my son when I'm trying to do everything that I can to be in his life in every way, shape, and form that I possibly can, from having people in Australia purchase him a record. Anything that I can possibly do to go out of my way to do, I've been doing for him. So he remembers and knows that I am in his life and I am his mother, and I am doing everything I possibly can to stay that way, regardless of the petitioner and his counsel's attempts to deter me from being part of that. I try to communicate with the petitioner in regards to my son. I've been continuously excluded. There is no communication. I don't know what else it is that I can possibly do that I haven't tried to already. And a lot of these, too, I would like to remind everyone, is these could have been solidified would they have had the meeting of attorneys and unrepresented parties meeting. A lot of this could have been had and resolved and narrowed if we were to have that meeting in regards to all of this. Nonetheless, if the petitioner would have answered a phone call or a tablet message, it's not fair to me that just because I'm here, it doesn't justify how I've been treated and excluded.
Okay, well, it's not fair. It's not fair. It's not fair that you guys automatically blame it on me. It's not fair. See, that is just not fair.
It's not fair to me that just because I'm here, it doesn't justify how I've been treated and excluded.
It 100% justifies why you are being treated the way you've been treated and been excluded the way you've been excluded. If cold-blooded murdering someone does not disqualify you as a parent, thus requiring distance and exclusion from some things, then there's nothing in this world you could do that would make you an unfit parent. Especially not in Sarah's eyes. She could do absolutely anything and not see a thing wrong with her and still call herself an outstanding mother to her son.
I don't think you all understand who I am, where
Well, tell me.
I mean, I've always been a straight-A student. I am an outstanding mother to my son.
Okay.
I excel at everything.
With it, I would like to continue to have the regular phone calls and interaction with my son, which I have been doing, and all of a sudden now is being tried to be taken away from me out of sight, as opposed to my son and his growth and him moving properly and appropriately and lovingly forward with his mother.
And there it is. You're trying to use the court again to basically force your son to treat you lovingly and appropriately moving forward. Because you're coming to the court to say, no one cares for me, no one's treating me right, and after I get this court order that orders me $60 million, as well as all the time with my son in the world, I'm also going to use this order to say you need to be moving appropriately and lovingly with me, and it's all your father's fault for not doing so. So it's always just, everything is centered around her. If you think your son cannot function or grow properly and that you cannot impact them or have a positive growth or do anything without daily phone calls, then you're probably not good at what you think you're trying to impart on him. You can still make that impact. It's about the quality of the conversations, not the quantity, but whatever.
And I would very much like, please, after 9 months of asking for my son to please come see me, which is only 50 minutes away, which I think will change both of our lives with finally being able to see. I don't know if you can hear me, but there's incredible feedback. Static.
We can hear you. Can continue.
Yeah, we heard you. You're just mad because you're not getting any feedback, so you can't tell if any of this is landing, and it absolutely is not. Because you keep making the same statements without actually making a point.
I would like, from the parenting plan, my resolutions, please. I don't know what I'm supposed to do if I say it again. If that's on record from previous.
Everything that you have said is on record. Oh my goodness. You don't have to repeat yourself ever. Of course it is on record, and you know this, you're just lost. So you're just spiraling again and again and again, and we're just going to keep returning to things. I'm waiting for anything new. Please. Just make up a lie at this point. That's right, Linda. Preferably a new lie.
Daily telephone calls, personal space for him to grow up as the teenager that he is. He's going to be a legal adult in 3 years, which is why I'm unclear on why he's fighting for this. So
he's fighting for this because he's actually fighting for his son. Unlike you, who are fighting for yourself to be in your son's life, and you have stalled and stalled and stalled, and this has been 5 years that you have been out of his life, and he filed this petition to modify and to cut off all of this bull in 2022. So you have extended this 3 more years. That's why he's fighting so hard, so that they can get those 3 years of their life to themselves. Again, I get it. In your mind, none of this matters because you'll only be in prison for the rest of your life.
In the Department of Corrections, with credit time served.
So 3 years is nothing. But in the flip side, 3 years is nothing by your account. So you should just wait it out, continue to develop your relationship with your son, and then when he's 18, he will want to come visit you. All the times that you say he wants to visit you right now, he will have all the free autonomy and opportunity to do so.
the petitioner, nonetheless, I've not been included in anything major or included in an ending period since day one. So I don't understand. But I'd like to have, please, tablet messages, all of the features, everything that I can possibly have still please to be in my son's life.
Everything I can possibly have to still be in my son's life. You are in your son's life. There are people who are actually out of their children's life. I don't know, for instance, George. And there are people who are alive who are out of their children's lives in prison for life just like you. You have access. You have admitted that you have access. You have admitted that you have been involved and that they just have not sided with you. So every time you keep saying, I've never been included at all, it's just a lie.
This is another reason why, too, that I was trying and adamant to have a guardian ad litem appointed. And I believe that I would like to suggest that some type of co-parenting course or counseling in regards to how to treat the other parent, which he has already taken, but back in 2018 upon our original divorce. So he can be reminded, please, on how to treat the other parent and also look out for our son's emotional distress that he has been causing him by calling me names and not speaking to me and giving me the silent treatment.
Now, how does that make any sense? Again, it's so childish. I want you to punish him by making him take a course just so it reminds him of how to treat me right. So it's a shaming element. You want to shame him into treating you right. Not that you actually want him to be informed or to get necessary tools needed to co-parent under these situations. No, you want to punish, embarrass, and shame him into doing what you want him to do. And you are now saying that he is causing the emotional distress, which the only testimony to someone causing emotional distress has been you causing your son distress after the way you talk to him. We've been over the texts. It's deplorable the way you talk to that person. You shouldn't talk to adults that way, and you for sure should not be talking to your child that way. That is what is causing him emotional distress. Not you saying Brian is causing him emotional distress by calling me names, by not letting him talk to me, by giving me the silent treatment. Who is this? Are you saying that he's causing your son emotional distress because Brian gives you the silent treatment? How on earth would this affect him whatsoever unless you bring it to him every time you talk to him? And then blame shift and say it's Brian's fault for forcing you to do that in the first place.
When I'm trying to speak to him solely in regards to my son, I'm doing everything that I possibly can for my son. I've been avidly striving to and will continue my pursuit to be even more meaningful to my son in my continued hard-fought efforts to see him in person while temporarily located at DOC and in the meantime of my appeal and my release and all other positive aspects that I have with my son on the horizon. I've encouraged him, acknowledged him, understood him, listened to him, believed in him, and I make him stronger and more beautiful. Foremost and above all, meaningful means love, which the respondent ceaselessly and immeasurably will always have to wholeheartedly provide for her son, which is priceless, and no circumstance or agreement or modification in any lifetime can change or end.
So she just went back to reading now. And I love that line, and I think I mentioned it in my original reaction in the future of, you hear that, Judge? She says, nothing you do can change anything. So this is all just a waste of time, and the only thing that can be gained here is me getting my money. Other than that, there is nothing you can do that will ever change my bond or get me a bond.
I'm hoping that the court can see my ceaseless attempt and whatever it is that I can do in order to stay in my son's life for longer than 30 minutes per week, please.
Boom, granted, because a million times people will have to tell you that that's not what's being proposed. One call a week is being proposed, not one 30-minute call. Ideally, just one 30-minute call, but we know you'd throw a fit, so you can do 2 half-hour calls just on the same day. So you misquoting this every single time just dilutes the overall impact of your arguments, because you're saying, oh, I'm not going to be included at all, and they're going to be like, okay, bet, now you're included, and then move right along. But if you made actual arguments about the necessity for that much communication, I mean, you don't have any arguments for that, thank goodness, no viable ones, but If you had made specific ones of, I need to speak to him this many times for this amount of time, you would be able to get somewhere. But you speak in absolutes of, I'm not included in my son's life at all. I would like to be included for more than 30 minutes. Bet. Gotcha.
I have a lot to offer, and I can help him grow in multiple ways. And I am his mother, and I wish that I had the guardian ad litem or my son to be included in this, which, if I can also include, please, into evidence my it's the notice of filing the respondent's answer, the supplemental petition for modification of final judgment, which is number 7, please.
Okay, give us just a minute. You said number 17?
7.
7.
Yes, Your Honor.
Give us just a minute. We pulled the wrong one. All right. So what I have before me is, it looks like petitioner filed a handwritten document on it's dated May 1st of 2022, but it looks like it was filed with the court on May 16th. And there was a notice of filing by Attorney Martell. Looks like he may have received a copy of it and he filed it with the court. Is that?
Let me just pull it up, Your Honor. I'm sorry.
It's okay. But I am seeing it both in the court file on May 16th of 20.
Is it an answer to our petition?
Yes. And it looks like you may have filed a notice of filing just to make sure it got into the court.
Yeah, no objection.
All right. So I'm going to receive what is presented as Respondent's Composite Exhibit 7, which is that notice of filing by Attorney Martell, as well as the actual handwritten answer. I'm going to receive that into evidence as Respondent's Exhibit number 5. All right, Ms. Boone, you may continue.
And this might be a good place to cut in real quick, because they're going over this document letter that she submitted, and I haven't actually read it on this channel, but I do have it thanks to Tanika. Thank you. So I want to just read that out real quick. I might not do this if she brings up other letters later on, but I'll at least do this one so we know exactly what she submitted into evidence and where she's trying to go with this. Plus, the letter is a disaster. May 1st, 2022, the marriage of Brian C. Boone, Sarah K. Boone, case number da-da-da-da. Dear Sir/Madam, I am writing in regards to a summons I received 4/22/22 stating a lawsuit has been filed against me in the aforementioned matter. As instructed, this letter will serve as my personal/individual written response to the supplemental petition, joint stipulation, and notice of appearance included. I am in the process of trying to obtain representation for this and diligently working day by day, doing the best I can, and am literally able with the little to non-existent resources I have available. Please know with great emphasis that I am doing everything possible to defend and protect myself as a person and a mother foremost, while incarcerated temporarily. I have nothing and no one to help me, as both my parents, grandparents, aunt, and uncle are deceased. I have an older brother who is unable to be located and a younger brother who is currently deployed in Africa for the Marines. I also have no counsel of any kind. Per the summons packet, I have tried to contact a referral service and legal aid via phone with no success due to the numbers being, quote, unauthorized in accordance to the rules of OCCD. I am working expeditiously to find an alternative way to contact and figure out some type of facilitator in the meantime. Your patience is greatly appreciated. As said, I am doing all I can to stress my dedication as well as the seriousness to this matter as a concerned parent, and how it is of the utmost importance to be rightfully conveyed and understood as the very competent, caring, loving, hardworking, determined person that I am, and whose, quote, mental ability to co-parent is undeniably obvious and without any doubt should be included in the ongoing nurturing of our son. My decisions, ideas, opinions, feedback, rules matter. To be excluded in any way just because of my current temporary
to life in the Department of Corrections
circumstances and location is wrong, unfair, and unacceptable. It makes absolutely no difference where I am. Jail, space, Australia. I am not and will never be useless, especially to our son. I am still his one and only mother. You are my son. I am your mom. Forever. No matter what, where, when, why. No matter anything. You can't delete, erase, blot out, omit, change, or remove. Stop being mean to me and not caring. I'm already going through so much, then to be disregarded and spat on by you is unspeakable, and for no reason.
Why is this happening?
Because George is dead.
Who loves, cares, and adores him beyond measure, and makes his safety, mental, emotional, physical, and spiritual well-being my priority, and will for the rest of my life. I was hoping you would actually listen and care and make an effort just simply to have your phone on and charged so I can talk to you. Why? I hope one of your resolutions, if you have any, is to be nicer and respectful to your mom. If you are choosing not to talk to me, I wish you'd just man up and tell me so I can stop looking like the fool you are making me out to be by calling just to be yelled at, called names, or hung up on. If you have nothing to say to me or care enough to include me and share your life, just be honest and say so. Do you delight in making me feel worse? Does it make your day knowing you make me cry and feel worthless to you? Who am I to you? Really ask yourself that. Punching bag? Daily joke? Unwanted friend? Yes. That's how you make me feel. Know that, son. I can't make you care. I can't make you love. It's your choice. Yours only. New year, new start, new everything. Your choice. Don't forget about me. Love always. Who am I? Every day you have one chance to shine bright for him, yourself, and others, including your mom. It's not nice to me to not be able to talk to you because it's not on. Remember, if your decision is for me to not be a part of your life and keep trying to talk to you, just say. Just say. Your response last time I asked was that you wanted me to be. I wouldn't know from the lack of effort and intention to make possible from you. What else can I do? Honesty and effort. Not asking much, but missing out on talking to you, my one and only son. Love, your one and only mother. You have so many things that are praiseworthy and positive to think of joyfully, most of all, him, and also including me. I love you. I hope you're enjoying your day, my lovely darling. I'm thinking about your sweet face and how much I love you. Love you, love you. I'll keep trying to call. Miss talking to you and knowing how your life is going. Please don't ever think I'm not a part of it. I am, no matter what or where. I'm never going to give up being in it, and for you, no matter what or where. I love you for everlasting to everlasting. Always know that. Talk to you later. You don't want to talk to me? It makes no difference when it is, as it's the same thing on the weekends. Anytime I call you, please don't think I'm not trying. It's you who are not. I hope you answer sometime. I love you. Make sure others remember how good you make them feel with all the softness, understanding, love, and positivity you can give to everyone, including me. I want to remember good things from you, which there is an overabundance of, now and future. Make a difference. Be the difference. Take the extra minute or extra effort to remember that I remember too how you make me feel, your mom, along with everyone you come in contact with. Remember, I love you. Thank you for your goodness. I will never stop being his mother and using my God-given talent and rights as his mother to remain so. One obscure, unfortunate incident. I'm sorry, what? Does not define me as a person or my entire existence. I want my son to know and show him I am always willing to exceed any limitations placed upon me that would hinder my relationship with him as his mother and being included in every aspect of his life, then, now, and future. He is my life. Who is former husband to assume and to quote, think his sole decisions are the best, fairest, and most successful for our son. I have God, my giving heart, functioning well above average. Functioning well above average, brain and bold voice to be my son's best advocate, as well as my own. I matter. If needed, our son should be included and asked his thoughts of his father attempting to remove my right in being his mother, and only ever be able to ask about his video games and what he had for dinner. Nothing of moral value or life defining. I am not the worthless, mindless, heartless, unproductive, non-contributing, poor and pitiful footstool he would like me to be and tries to make me out as to others. It makes no difference where I am. It's who I am. Mother, now and always. And again, one incident does not define me or my entire existence.
Why is this happening?
Because George is dead.
Guilty of murder in the second degree.
Sentences you to life in the Department of Corrections.
I have so much to offer in so many ways, and it would be extremely detrimental, as well as a great loss,
George is dead,
to not be able to continue in the shaping of our son and his very extraordinary life. Is former, quote, husband able to handle the consequences, burden, and heartache should his decisions jeopardize or harm the best possible outcomes and inhibit the absolute success our son could have been or had?
Why is this happening?
because George is dead.
Someone needs to call Brian, please. Okay. Or can I not make a phone call? So what am I supposed to do now? Someone needs to call Brian. But how long will that take? Because I need to talk to Brian.
How will this sole great responsibility, should it be awarded, affect the former husband's mental ability going forward, as all instances, scenarios, and situations are not the same? That is why there are two parents, both to broaden all horizons, outlooks, and futures for their children, and in which I am so desperately fighting now to continue to do for mine, and all for the right reasons.
George is dead.
See, and then it's all backfired on me. Like, it's all backfired on me. And I understand the severity of this.
He's dead.
It's awful, I know.
Okay.
It's awful. And I will tell you both this right now, too.
I am no longer going to willingly make it easy for former husband to advantageously rob me of my last and only minute life resources.
George is dead.
Out of bitterness, greed, and spiteful opportunity. At my weakest, broken, most vulnerable moment, he is attempting to take full advantage of such with this unwarranted, vicious attack, thinking, hoping, and assuming I will wave a white flag, which I do not own, especially when it comes to my son. He is wrong in doing so, knowing fully the playing field is not and has never been even. All odds are against me due to my monetary restrictions and lack of support system. It is illogical and futile to try and have a conversation or discussion that is real, rational, or legitimate with former husband about anything. Then during our marriage and now, His superiority complex and ongoing dishonesty have made it very difficult and sometimes impossible to work with him. This in turn has compelled me now to bring to attention some of my concerns in the egregious decisions he has made prior and during my incarceration, as well as from my son personally stating, quote, Dad's laziness, empty promises, and disappointments. Son knows without any hesitations or doubt I will do anything, anytime, anywhere, all within reason, to help him, which is why I, his mother, have been his go-to person in many ways for many things throughout his life, including while being incarcerated. Former husband is penalizing me because I care nonstop and I have regular ongoing concerns, questions as our son continues to grow that are important, needing to be discussed. Our son can and will grow better, stronger, brighter with my decisions included also, as they have been since I brought him into this world. Former husband and I did this together, and I may be obsolete to him, but I am not to my son, nor will I ever be. If you are choosing not to talk to me, I wish you just man up. So stop trying. When trying to speak to or with former husband and have an opinion, idea, belief, feedback, etc., that is not in line with his or his parents, I have been laughed at, completely ignored, and disregarded, given the silent treatment, berated, and made to cry or hung up on, most every time in front of our son. This, to me, is setting a poor example of how a man, husband, should treat a woman, wife.
Why is this happening?
Because George is dead.
On top of being a bully, son hears and sees how former husband, his father, treats, degrades, and judges me, his mother. This is extremely confusing and sad to our son, as he knows I only discuss, or try to, anything that pertains to him. Please respond. Please do not have to make me go through my son when I call to have him ask status of everything. Dad says you're annoying and beg all the time. Son told me after asking him to ask former husband if he finally ordered a book and hot meal after being made to call daily to check for 13 weeks. Make the effort, Brian. Part of the solution, not problem. Remember? Not being a lying, malicious, unhappy, bad example to my son on how you think it's acceptable to treat me, his mother, and other woman. And yes, what you are doing is and has been proven mental and emotional abuse. It's recorded again and again and again and again, again and 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 oh my God. Whoa. Oh my. He hears me being told indirectly I am unimportant. This is unacceptable, damaging, and mean. Also having lasting effects, an inherited trait led by example of his father and serves no purpose, quality, or value. A bad decision. What former husband is trying to do is sweep me in a dark, bleak corner and keep me there, hoping I find no way out.
I would do anything for him.
Well, you gave up checking up on him. So.
Wouldn't let him out of a suitcase.
Oh, gosh. But he could push it open.
No, he
Did
couldn't.
So, but why would he start doing it?
Because he couldn't, because it was all the way zipped.
Okay.
Didn't see it.
It wasn't.
And then you flipped the bag around several times.
I didn't do that intentionally.
You didn't intentionally flip the bag around?
No. Why would I do that?
Well, you
Good
told us
question,
you
you
did.
did.
When he was upside down.
Right.
Well, you had to put him upside down. So you just left
I
him there
didn't
to
kill
teach
him.
You left him there to teach him a lesson?
I didn't mean to leave him there. That's what I'm trying to tell you. Because I'm looking at the hole, knowing that it's there. He'll get out and no home. Because you
And
don't.
then he doesn't.
I'm in the bed.
You even moved.
And dozed
I mean,
off. I didn't want him to be like that. Don't.
You didn't want him to be upside down. How do you even get upside down?
Right. You guys are killing me right now.
What former husband is trying to do is sweep me in a dark, bleak corner and keep me there, hoping I find no way out. The quote, relief he is seeking means to remove any additional work, trouble, effort, concern, responsibility, etc., which would make former husband be the reliable, caring, consistent, honest person he should be. How especially to our son, and who I always wanted and needed him to be when we were married, possibly altering the current situation for everyone. Oh, okay. So now it's Brian's fault you murdered your boyfriend you cheated on him with. If I have no authority, power, or control, there are no discussions or interactions of concerns, ideas, plans, future our son does and will need involving both parents. Me, the other parent included. Not only am I continuously disrespected, I am verbally threatened with some form of this looming lawsuit. In former, quote, husband's original verbal threat made sometime last year, early 2021, to take away my parental rights and funds necessary for my, quote, livelihood while incarcerated, after my sincere, heartfelt begging while sobbing to him while on the phone in the middle of my dorm, in my desperation asked why was he doing this to me, fully and completely knowing I have nothing or no one, and how meaningful it is to me to be called son's mother. His response was simply, quote, it will make you say yes now. If you keep doing as you have been, everything will be fine. I have been saying yes, as I had no choice if I'm even asked anything to be able to answer. I am unclear, as usual, when dealing with former husband, of his behavior with these new revised threats and demands that I have not already submitted to previously, seen, or even knew existed until now being served. I will not be erased or downgraded to nothing because former husband is bored and bitter. Totally unfair.
And it's not fair. It is not fair. You guys are trying to, again, oh, he's in there, night, night. Like, this is not fair at all,
Yes.
that you all are assuming that that's from me.
You didn't float up downstairs.
Okay, well, it's not fair. It's not fair that you guys keep trying to say that that's what I did. It's not fair that you guys, just because he has those, automatically blame it on me. See, that is just not fair.
And the cruel ego trip is disgusting and nothing to be proud of. What is the point? There is nothing left other than my dignity, which he'll never have. What would our son say? How would he feel knowing the truth? Please know, I do still have numerous other legitimate concerns needing to be addressed in the petition and personally, and should be by any decent parent respondent. This is not a one-sided attack, and await the opportunity to clarify my specifics if when needed. I, the mother to our son, believe said concerns are very important. I've realized also this, quote, lawsuit may be my only opportunity due to my restricted resources to have them handled and hopefully remedied professionally, positively, and fairly. I am praying I can be heard, seen, and included by this letter in the ongoing proceedings, meetings, discussions, etc., futuristically. I am hoping also to have some type of representation to amicably bring this matter to a concrete conclusion, being beneficial to everyone. A copy of this letter is also being sent to legal aid. You sent this letter to to legal aid for review and assistance. Wow. No wonder they said no. In the meantime, I am still, quote, mom with my, quote, mom rights. The level of this, quote, lawsuit is unfair, unnecessary, and uncalled for. This lawsuit is also from one monotone side of former husband. I, the former wife, have a side also, intellectual, willful, and valuable. deserving to be heard. I am also fully dedicated and devoted to my son and his rights. His uninfluenced feedback should be included, and it is only fair to him to know the extent of the situation and the cruel attempts of his father to his mother. No one can tell the future or assume to. I was unaware former husband had a crystal ball. I have faith and will always, this being something no one can take from me ever. No one either is better than anyone in this or ever. And money can't buy everything, especially love, grace, understanding, and goodness. If former husband is willing to have a rational, reasonable discussion, however mediated, I am more than willing and welcome. As said in my previous letter, no one has a crystal ball. I do not know 4 months in advance my location or status, making it impossible to determine the best date to choose from which you have proposed. With that being said, my questions are as follows. Those weren't the concerns. 1. What are the requirements under Florida law stating a mediation needs to be scheduled? Is the point of this mediation to try to force me into signing or agreeing to the only terms available presented by former husband? What if I do not agree? If there's anything else I can do to show my very good intentions other than writing this letter expressing my desperation to continue to be included in my son's life, my understanding of the emergent need of counsel and sheer hope of a resolution, I am also willing to submit to a competency test or any kind of test to show my capabilities mentally and full ability to co-parent. I am not the ridiculous, ruthless, degenerate felon former husband slanderously assumes I am.
Will the jury find the defendant guilty of murder in the second degree?
Court sentences you to life in the Department of Corrections.
I love my son immeasurably and have a limitless abundance of positive, meaningful, solid, contributing life characteristics to share and have my son inherent from me, which is priceless. I can co-parent. I want to co-parent, especially if former husband is going to positively participate and understand rather than pillage and point fingers. A mother is her son's first love, in which I very much and with every fiber of my being want to still be. Thank you for your time in reviewing my formal written response in part of the petition. I am grateful for your understanding and hearing my side also, which is only fair and right to do. This is between both parents. I await your response and instruction. Please do not hesitate to let me know if anything further in my ongoing unreserved cooperation is needed. I am still in this, still a person whom former husband was married to for 13 years and has known for more than 20. Most of all, I am still the mother of our son and still important in anything, everything pertaining to him, come what may. Sincerely, Sarah Boone.
This was just me trying to be transparent with the petitioner's counsel and describing to them my need and want to be in my son's life back in 2022. Explaining my dedication and my decisions and ideas and opinions, they matter. One obscure enforcement incident does not define me as a person or my entire existence.
One obscure, unfortunate incident does not define me as a person or my entire existence. And again, one incident does not define me or my entire existence.
One obscure enforcement incident does not define me as a person or my entire existence. And I'm trying to be my son's best advocate for myself. And 2 parents are involved.
Correction, 2 parents were involved. One parent more than the other already consistently, but 2 parents were involved until one decided to go kill another parent who is now no longer allowed to be involved in their children's lives. You still are involved, just not as much as you want. And just what are we saying here? I'm trying to be my son's best advocate for myself? What? No, that doesn't make any sense, but it reveals what you actually mean. You don't mean you're trying to advocate for your son. You mean you're advocating for yourself through your son. And you wish your son was right there in front of you. Let's just say he had a terrible day the night before for any imaginable reason, right? Life just hit him and he was on the verge of tears for no reason, right? This isn't just an everyday occurrence or whatever. It's just situationally, that's what happens in that courtroom that day. She would use those tears against him in front of his face if she thought it would benefit her. That's the level we're at. And there's no world where I ever think that she sees her child in distress and puts her own needs aside for him, especially when it comes to getting money, freedom, resources, the minute amount of resources, etc. And all of that was your choice. No matter how much you want to distance yourself from your actions, you chose every single step of that night. Bat, zipping suitcase down the steps, moving it, filming, hitting, flipping, all of it. Decisions nonstop, walking away, going upstairs, allegedly, we truly don't know. Falling asleep, I do believe that happened. Waking up and then regretting that you didn't let him out. You never regretted a single decision that you made that entire night. You regret that you didn't make another decision and do the action of unzipping him. If you did that, you have no issues with anything you did. To this day, you don't think you did anything wrong that night. At least you haven't admitted it, and that would make you look more human if you did. So, if you really want to play the long con manipulation, how about show some actual remorse, get people on your side being like, oh, maybe she's not actually the self-centered and self-serving always. There's just like a lot of barriers up, but underneath there is this person made of gold and forgiveness and broken pottery and all of that. But then you peel back the layers and you're like, okay, this is still an onion.
Just because I'm not there under the same roof to make the same decision, or at least I would like to be conferred with and included on so I know what's going on in the son's life. This is just me trying to know what is going on and to let them know what I'm striving for in order to come to some type of cooperation or collaboration. It was just me emphasizing to them that I very much would still like to be in my son's life.
Is that what y'all took away from that letter? Because that's not really what I heard when I read that letter. She loves to, I say this all the time, she loves to get big and bold in these letters and then softens it when she's in court and she realizes how ridiculous it actually sounds if someone were to say those words out loud. So then she softens it and says, this was just me trying to show my heartfelt effort to be involved in my son's life and that my rules and ideas and thoughts and that they matter. Meanwhile, in the letter, y'all are...
I said, bitch, get the fuck out my face. Why are you in my face? Why are you recording me? Why is she videotaping? Ain't you supposed to be security? Like, cause I don't give a fuck who you are. I don't give a fuck who you are. Security heavy. I said, that's a fucking lie. Fuck out of here. Just trying to get some money.
Who's trying to get some money?
She is.
I am his mother. I am a woman. I win. He's excluding me. He needs to do this. I want my son included. Even back then, she is trying to literally force him into a traumatic situation when she's going like, I wonder how he would think how you would treat me. Thinking like I'm trying to make you emotionally harm our child when he sees how you treat me. And I'm okay with that. Meanwhile, everyone else, court, Brian's attorney, are like, let's leave the child out of this because he has nothing to do with this. It's just your sorry attitude that is holding everyone else up. And I'm going to try to hold back on my comments about that letter because I think I'm just going to clip that out and do a whole video on its own about that because I have so many thoughts on it. It was absolutely ridiculous. But yet again, she says, obscure, unfortunate incident. You are just a very disgusting human being every time you say that. These inaccurate, unnecessary modifications. The relief he is seeking could have been avoided until he decided to involve our son and my maternal rights again. One obscure, unfortunate incident. I'm sorry, what? It is so unredeemable and unconscionable that a killer would say that this is an obscure, unfortunate incident, as if this whole man's life means nothing, and you've done it time and time again. That's specific wording too. It's one thing if you do it once and it's already horrible enough, and maybe you change up the wording, you're still trying to downplay it, but it still sounds awful however you do deliver it. But to do the same exact wording means you stand 10 toes behind it. You are calling your murder, the murder that you committed, an obscure, just a random thing. It hasn't happened a lot. Unfortunate. Yes, it's awful. I get it. He's dead. Why do we have to keep talking about it? Incident. As though this wasn't a violent attack with a bat, forced confinement, and multiple assaults afterwards and up until the moment he died. Because we don't know if she ever stopped abusing him when she turned those cameras off.
That is my letter originally in answer to their modification of this final judgment, which we are in the process of debating. For also the parenting plan, which is still active, the original from 2018, I believe, I wanted to bring to the court's attention that it's been violated by the petitioner. Again, from previously, now I believe it's a time where it says the parenting plan may be modified or verified on a temporary basis when both parents agree in writing.
All right, Ms. Boone, you have to agree that there's a lot that's not being followed with regard to that parenting plan.
Yeah.
Which includes even the time sharing that you're not able to do at this time.
Right.
You would agree with that, correct?
I understand that, but that is my only stipulation. That's my only part that
All right, you would also agree that that parenting plan was entered into back in 2018 prior to there being any criminal charges in your incarceration. Do you agree with that?
I do, Your Honor.
Yeah, double homicide.
Okay, and you have to also agree that when the parenting plan was entered into, if I remember correctly, you all agreed to the parenting plan as part of your mediated settlement agreement back in 2018. And at that time, neither one of you were contemplating any type of criminal charges.
Double homicide.
Or incarceration. Is that correct?
Bitch. No, I'm sorry.
Yes, Your Honor.
Yeah.
Okay. All right, you may continue.
Pause, because not yet. Damn, the judge just went full lawyer on you and just cross-examined you because you would not stop going in a circle. Because after you keep floundering and floundering, you said, you know what? The way I'm going to wrap this up, I don't even know if this is wrapping up, but the way I'm going to tie this argument in the bow is I want to bring to the court's attention that the petitioner has violated the parenting plan. The one that everyone has violated at this point. That's why we're at trial, to create a completely new one and to figure out what we do with all the violations that have taken place. However, while Brian's side has accepted responsibility for anything that could be kind of shady and hasn't really shied away from anything, you have not taken responsibility for anything. You are saying that you are the perfect co-parent. You have done nothing wrong, and every single thing we hear is wrong, wrong, wrong. Abuse, 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 lie, lie, lie. The judge had to confront you and make you agree that you have also violated the parenting plan. And you go, well, yes, I understand that, but that's my only violation. We have gone through violation after violation that you have actually brought up yourself. we have all this information and most of it comes from you, it's because all she does is make admissions. When you said the parenting plan says that communication is supposed to be between the parents and not between the child. Well, if you don't answer my phone calls, then how else am I supposed to communicate with you other than through my child? What does that mean? I'm admitting to breaking the parenting plan. But I don't take responsibility because you forced me to do it. As long as she can blame George's death on himself and to say that he was a bad person so he deserved it, then she did nothing wrong, and why are people trying to treat her different because of it? I can tell already this judge is going to have a field day with her in this in this judge's order, because she has had it. And also what she doesn't know is that in Judge Jackson's background, unfortunately, her father was killed by her mother. I believe she shot him. So that is like a very foundational moment in her life and may have been the catalyst that got her involved in family law as a judge. So her trying to play this mother card, I'm a woman, he shouldn't treat me like this, how could you, this is so this is so that. Meanwhile, we see nothing but abusive and violent actions from you. I do not think it's going to read well with her. And I don't think that's going to bias her in one way or the other, but it's definitely not going to bias her in her favor. And that's what she has banked on all her life. She's banked on there's someone in the room who follows the social rules that she tries to manipulate and will take her side. You think she'd take the hint here? This is not going well. Maybe I should wrap it up or talk about something relevant. You know, the issues at hand.
So I would like to bring in the part of the divorce certificate, which include each parent and everything they're supposed to abide by regarding being appropriate to the other parent, regardless of incarceration or not. That's what I was trying to say. I've been excluded this entire time, and everyone has blamed my incarceration on it, which it shouldn't be like that because I'm still the mother of my son regardless of where I am. And what petitioner has been saying and doing and not doing are unacceptable and to a certain extent unlawful, especially with the active parenting plan. It shouldn't be done anyway with trying to hinder my relationship with my son. There's no reason for him to do that. And again, in conclusion, the continuation of his responses, I don't care. That's what I've gotten since I've been here. So do I bring case law up right now, or is that something I could?
All right, if you'd like to bring up case law, you can.
Okay, we have finally reached the case law section. I heard that this part was just a mess, so I just wanted to cut in here and say I think we finally finished with the major arguments or the worst of it. I know this case law is about to be a mess, but in terms of like her just rambling incessantly, at least the case law is something that you can focus and hone in on. She has a goal of I need to put in this case and misuse it and just prove how it doesn't apply to my situation whatsoever, but at least I could say I tried. Linda, you know what? You are absolutely right. We are past trying. Trying is no longer good enough. That'll get you some participation points in school. I'm sure you were great at getting your straight A's there.
I mean, I've always been a straight A student. I am an outstanding mother to my son. Okay. I excel at everything. I don't know what to do, how to do it, and I always know what to do and how to do it.
But here in this courtroom, we need to go past trying, and you need to make viable arguments, or you need to stop fighting this so much. You spent all these hours running around in circles, not making a clear, coherent point about anything, aside from he's making me feel bad, punish him. But not only did she submit the parenting plan certificates, or look, we completed this divorce class that said something, no parental alienation. Now I'm also submitting the divorce certificate, supposed to show how we do divorce. So I'm guessing there's 2 classes or 2 things they had to go through. Or maybe this is just the same thing and she looped back around and just had to talk about it again of, here are these certificates again. All you have to say is, we both took a class and we received certificates for doing that. You don't even have to say that. You can just say we both took a class. The judge is not going to be like, well, prove it. I'm not going to believe you actually took a class unless you submit the divorce certificates. It's such a weak argument to begin with. I don't understand why she spent so much time on it when it could have been 3 sentences. And the never-ending nerve to say, everyone's blaming my incarceration on this, and it shouldn't be like that. Because I'm still the mother of my son, regardless of where I am. And she said that before of like and nothing can ever change that. No modification or court order can ever change that. Again, giving an FU to the judge saying, I don't give a shit what you have to say here. I will never stop hounding my son to love me the way I want to force him into loving me, and to blame everyone else for whatever decisions I have to do to make that happen. These answers are wild, and this is exactly what judges hear when they hear, oh, we have finally reached the threshold of needing to cut as much contact with this parent as possible. And she always, she acknowledges the obvious of, in the interrogation, you're accusing me of this crime, you're accusing me, and a bunch of other things I'm being accused of. It's not fair that just because he has all this evidence that I beat the F out of him, it doesn't mean it was from me. Why are you guys automatically blaming it on me? And then ... Okay, yes, I did cause those injuries, and yes, I did do it intentionally, but I mean, I was just lying because I was afraid of getting arrested, meaning I lie when I'm afraid of losing things that I don't want to lose.
Because it makes it sound like, to me, like I'm being accused of something that was not intentional. I'm being accused of it. Mm-hmm. And a handful of other things that I'm being accused of. Okay. I'm not admitting anything about being intentional and I killed George. That's not the situation, but it's trying to be pinned on me.
Okay.
That was not my intent. But it's trying to be pinned on me. So however or whatever it is I need to do in order for that to be proven, then I need to do so, which is why I'm trying to get my ducks in a row.
Can I tell you something before you call and whatever? Mm-hmm. I've been arrested before because I fought back. I did my best. So whatever he has or whatever it is, it's not me.
See, this is what happens. It's not fair that you guys, just because he has those, automatically blame it on me. Y'all are making me out to be a person that I'm not. Or will I ever be. It's both of us. It's both of us. And it's not fair that you all are assuming that the marks that he has on him are from me.
We asked you where they came from.
I have no idea.
Well, nobody else was there, so nobody else was there.
I have no idea. I swear I did not lay a hand on him.
Okay. You just zipped them in the back.
Nor he.
You made those injuries.
I did.
We've seen the photographs.
Yes.
We see the bruising. Is that from that bat?
Yes. Yes, I kind of pushed, I held it with the skinny part here, and then I started with his hand, and his hand, he was still trying to get out. He was still trying to do that. So I started to push on the suitcase around it, hoping to have his hand retract and go back inside.
I swear I did not lay a hand on him.
Okay. You just zipped them in the back.
Nor he. What do I need to plan on? I promise you, on my son's life, it was not intentional. I promise you, on his life, it was not intentional.
I mean, if you're promising on your son's life, that's fine.
That's how much it means.
Sorry.
That's how much it, look, that's how much it means. I hope you take that to heart. Please.
I lied to the police. Basically everyone, because...
Like I was telling her, like, yeah, that's bad. Like, which I swore on my son's life was not intentional.
I was extremely fearful of being arrested. I made the first attempt of me calling 911 by telling them what happened, and I thought they were going to help me, but instead I was arrested for calling 911.
So you made a decision to lie.
I did.
Did you stay with that lie?
I did.
Are you telling the truth today?
I am.
So that's why I'm trying to figure out what I need to do for myself.
Okay.
So obviously I'm going to lie my ass off in this family court trial to get as much punishment to everyone else and to get me as many things as I want. Can you just imagine if the roles were reversed? If Brian were in prison after killing his girlfriend and is demanding all of this, demanding that Sarah pay for his livelihood inside just because somehow, you know, Sarah won the lottery and now he's getting spousal support and making her da-da-da-da. She would lose her mind at the idea of the father making those arguments. But because she is the mother, her son's first love, the one who brought him into this world, that means she gets special privileges that the other parent doesn't. And that means no matter what I do, you can't get away from me. Those are my God-given mom rights. It shouldn't be like that. It absolutely should, because then people like you would get away with it and there would just be a never-ending pile of victims. You've already left plenty in your wake, but that's why we have the court systems to finally stop you from inflicting more pain and suffering onto others. You wanted to say, George, all George caused you is heartache and pain. Heartache and pain is all you caused me.
You do everything to me all the time. All the time. Heartache and pain is what you cause me. Heartache and pain.
How's that?
Keep going. And I dare you. I dare you. I dare you. Get away from me.
Dude, nobody's doing that.
I'm gonna fucking hurt you.
I swear I did not lay a hand on him.
I'm gonna fucking hurt you.
That is all you cause anyone. You spread as much heartache and pain around you so that everyone else feels in your mind a fraction of how you're feeling on the inside. And because they made you feel that way on the inside, it's okay that you're trying your hardest to make them feel that way in return. And the nerve to say, and this is just unacceptable, everything he's done, and to a certain extent unlawful, seeing how this is the active parenting plan. The woman in prison for life for murdering someone wants to talk about someone committing something unlawful. Oh wait, I thought that criminal actions had nothing to do with family law. So why are we bringing that up? It shouldn't matter. Let's just say he did break the law. According to you, that shouldn't matter to this whatsoever. So why are you bringing it up? Because you wish, she wishes more than anything that Brian was the actual criminal, because that just fits her narrative that she's had all her life. And the fact that she's finally been shown a mirror of herself that she has tried to look away from for so many years, she's shocked that we see the reflection she doesn't want to see. That's right, Linda. I ate with that one just a little bit. You know, I had a little nibble.
Security heavy.
But keeping it going, if she actually looked at that reflection, took it in, tried to make corrections to herself, tried to be self-aware and look at what everyone else is seeing, then maybe people would want the best for you. But they can't want that yet because you're not there. She is one of those people who has to hit her absolute rock bottom before even getting a spark of intuition as to her own role in all of her issues. And how does she wrap up her best arguments? You know, the reason she's here for the proposed parenting plan, the alimony, attorney's fees, child support, all of those things. She says, in conclusion, all I've gotten in this whole thing from Brian is, I don't care. She is hurt so much at that. She really can't stand that people don't care for her. And I get it. That's hard to hear. And I get it. That would be painful for anyone. However, you can't just ignore all of the ceaseless actions you've taken. You have never once backed down, let up off the pedal. It has been full force since the moment you were put in those pink cuffs. You have thought that you still are entitled to everything, and anyone who tries to take anything away from you is abusive, wrong, unlawful, and should be sanctioned. They're the real killers in your mind, because they're trying to take your livelihood away and make you feel this and make you feel that. Who cares? We have gotten to that point of you can feel however you feel, and you need to feel that way. If you feel bad and think people are punishing you for your actions, it's because they're punishing you for your actions.
Okay. So, I'm looking. Excuse me. Thank you for your patience. Children. Okay. In regards to children and the parenting plan, Hunter versus Hunter, the court ruled that incarceration in and of itself is insufficient to terminate or deny custodial rights unless continued contact is shown harmful or detrimental to the child.
All right, give me the case name again.
Hunter v. Hunter.
All right, do you have a case citation?
Yes, Your Honor.
The number, okay, give that to me.
540 S as in Sam, O, 2, D as in dog, 235, in parentheses, SLA, 3, D as in dog, DTA, 1989, in parentheses.
189?
Yes, 1989.
All right, you may continue.
Thank you, Your Honor. Also for that case law, the court has discretion to restrict visitation only to protect the child. The petitioner penalizes the respondent for her incarceration. Also, it reinforces that inability to communicate, not incarceration, is the key benchmark for limiting shared parenting. I have multiple ways of trying to communicate with my son. And I've been trying every single one and trying to share parenting as best as I possibly can while located here. In fact versus fact.
I'm sorry, were you done, or are you looking for your next topic?
Forgive me. I'm reading another case law to you.
All right, I have the Hunter case. I've gotten that. Do you have another case?
Yes, I do, Your Honor.
All right.
Please.
All right, give me just 1 minute.
Thank you for your patience.
All right, your next case?
Ogilvy, O-G-I-L-V as in Victor, I-E.
Prestidigitation. Prestidigitation.
That's correct.
All right, just give me the citation for now.
Forgive me. 2007 SL 2D DTA. Ogilvy versus Ogilvy.
All right, you may have to give me the spelling of the name again. Go ahead. O-G.
I-L-V-I-E.
V as in Victor?
Yes, Your Honor. This holds that...
Jennifer, hold on. Jennifer Ogilvy versus Dale Dean Ogilvy?
I don't have their first names, Your Honor. I just have Ogilvy versus Ogilvy.
All right, well, the case citation you gave me is not a a formal case citation.
Are you not ashamed of yourself? Are you not embarrassed? This is really embarrassing.
So I have to figure out if I have the right case here.
If I may,
All right, go ahead and tell me go ahead and tell me your position on what you believe the case states.
It holds that parental alienation tactics, like disparaging the other parent or withholding visits, constitute interference and harm for the child. I have limited resources at the law library, so forgive me.
And do those limited resources in your law library in the prison give you fake or inaccurate citations? Or maybe someone else? I have questions.
No, you're fine. I just need to make sure that I have the right case, and I believe I do.
And then I have another one after that that has the same type of.
Give me just a minute. All right, counsel, for the record, the court has found the Ogilvy case that I believe she is referring to, which is 954 Southern 2nd 698.
Yeah, I got it here too.
Which is a first DCA opinion in 2007. All right, your next case.
Logria, it's L-O-G-R-E-I-R-A versus Logria. I don't know if I'm saying that name right. Sorry.
All right, is that 322 Southern 3rd 155? Do you have that?
All I have, Your Honor, is 2021 3rd DCA.
All right, for counsel, I have that as 322 Southern 3rd 155, Florida 3rd DCA, June 2nd of 2021.
Got it. Thank you.
I'm sorry.
No, you're doing fine. We just have to locate it based on what you're saying, and I just want to make sure that I have the correct case, okay?
Thank you.
So give me just a minute. I believe I found it, and I just need to make sure that I give counsel the citation that I'm looking at. So that's why it's taken a little bit of time, just so that he's on the same page, that he's looking at the same thing the court is looking at.
Yes, Your Honor, thank you.
All right, and why do you want the court to consider this Lagrera case?
Any restrictions must be court-ordered based on evidence and accompanied by a fair hearing. Unilateral actions are ineffective and wrongful. It also emphasizes the need for due process before suspending parenting time. I have two more after that, and I'm complete with it.
All right, give me just a minute. All right, the next case you have?
Thank you. Perez, T-E-R-E-Z versus Perez. And I have the citing.
Okay, give me the citation.
769 SO2D 389 parentheses FLA 3D DCA 2000 in parentheses.
All right, that was 760.
No, 769.
760. All right.
Did you
For
need
counsel,
the
the
summary
court,
part?
hold on a minute, ma'am, hold on. For counsel, the court has found the Deborah Perez versus Jorge M. Perez case at 769 Southern 2nd 389, Florida 3rd DCA, 1999.
I found it.
Hold on 1 minute, ma'am. All right, why do you want the court to consider the Perez case?
Because this underscores that restrictions on parenting time must serve the child's best interest, not a parent's convenience, retaliation, or preference. Also, require proper legal process and evidence, not unilateral actions to alter the parenting plan's time sharing term, regardless of where the parents are located.
All right, hold on just 1 minute. All right, you may continue.
Yes, please. If I could please add one more. I have 2 more and then I'm complete.
All right, go ahead.
Thank you. It's just stated as in regard to adoption of children by LAS, and the citation is 650, capital A is in apple, 2D, 214, in parentheses, 1994.
All right, that was 650A2D202.
214.
Counsel, have you had
I couldn't find it.
We cannot find that case.
Are you not ashamed of yourself?
Yes, please, if I could put a substitution in.
Are you not embarrassed? This is really embarrassing.
If you can do what?
May I substitute one for that? I have another one in place of.
Okay.
If I could just give you the citation.
Yes, that's fine.
It's 996 SO2D 930 parentheses FLA 2D DCA 2008 in parentheses.
Counsel, the court has found R.E. versus Department of Children and Families at 996 Southern 2nd, 929, Florida 4th DCA opinion from 2008.
Got it.
All right, and why do you want the court to consider this case?
Thank you, Your Honor. The court found that incarceration alone is not ground for termination of parental rights, and they still have the right to raise, contact, and participate in their child's life unless proven unfit on other grounds. And one more.
Before you continue, I have not heard any arguments or evidence that anybody's trying to terminate your rights. That's my understanding. That's not what's happening here. Is that correct?
Yeah, this is not a TPR proceeding. Yeah.
Got it. All right.
Hello?
All right. You said you have another case? All right, actually, hold on. Before you go, Ms. Boone, I don't know if you heard the court wanted clarification from counsel for petitioner. Based on everything that I've read and the testimony that I've heard here today, this is not an action to terminate your parental rights. Counsel confirmed for me that that is not what petitioner is seeking in this case. Okay, now you can go ahead with your next case.
Yes, please. If I may comment on that, it is in regards to me speaking to my son one day a week for 30 minutes, and that's what I'm trying to
terminate. I understand that, ma'am. What I'm saying to you is the case, and the court does understand, and there is a distinction between terminating parental rights and requesting a specific parental responsibility. So, this case is not about terminating your parental rights, and the court is not considering a request to terminate your parental rights. But you can continue with your next case.
Okay. I'm just trying to clarify what my parental rights are.
No, you're not. You're trying to force your own definition of what you think your parental rights are. You're not trying to seek clarification whatsoever. You are mad that you don't get 8,000 phone calls a week. You're mad that Brian is proposing you have 1 phone call a week and you can't take it. Your eyes have just seen red ever since. So him limiting you to 1 phone call, even though he's going to have 1 in-person visit monthly, is him terminating your rights, getting rid of all of your rights. You can't use this all or nothing big, huge language in the court system. Words mean things. So when you say your rights are being terminated, they have to respond with, no, they aren't. And then you freak out saying, yes, they are, because I deserve unfettered access even though I'm locked behind bars for the rest of my life. That still shouldn't prevent me from having all the access in the world to him. And if you try to limit that in any way, then you have terminated all of her rights. This type of language does not work in courts. And I'm trying to let it play out as much as it can because this is just cringe. And I cut out a lot of dead air in between these things. It's like the spelling bee from hell.
Prestidigitation. Prestidigitation. That's correct.
Hearing just letters, numbers coming out of this loudspeaker. I can only imagine what it was like in that courtroom. Nightmare fuel.
That's correct.
And it's like, I get she's over the phone, but she's also over projecting way more than she knows she needs to. But she wants to overemphasize, I'm over the phone, so I need to make sure you hear me. And that reminded me of in Volume 4 text messages when she was mad because she didn't have access to the break room because they put her in a small closet next to the break room. And she said, they yelled at me because it's so loud and everything echoes. It's an effing cluster F. I can't make it up as I experience it regularly. The last time I asked a question to the sergeant about using the briefing room because they kept sticking me in a closet-sized room made of glass and echoes because they wanted to use the room for a party, then I get screamed at for talking too loud because the glass is too thick and it echoes. Which, pause, because this is like, it's bothering me. That's not how physics works, right? So if the glass is too thick and you are in a small closet, that means that your voice is louder to you, not to the people in the room next to you. If it's thicker glass, it's going to be even more silent. If it was thinner glass, then yes, the sounds would creep over there. If they are still hearing you through the thick glass in a small room next to them, that means you are deliberately raising your voice out of frustration of being put into a small closet and now trying to reframe this. Now you're blaming me because I get yelled at over being in this closet where it's so loud that it echoes. Yeah, it's loud to you. Oh. Long story short, she's basically screaming in that small closet in order for them in the next room to hear her, since it was a very thick glass by her self-description. So if you make her upset and you do something she doesn't like, then she's going to make sure you know about it, and she's going to make sure it's your problem too. Because once you fix all of her problems, she'll stop being a problem for you, which is the rhetoric she has used against Brian for years. If you just paid me all my money and did absolutely everything I said, I wouldn't be hounding you, would I? All I'm asking for is a $6 hymnal, coffee, food package, blank ordered these one-time requests. I would not blink asking, when are you? Would I? 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 I'm crashing out. Would I? 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 You not cooperating blank, doing what the court and judge have told you to do blank, do differently until my supposed unknown predicted trial. Which even that confirms that she's been so self-aware of all of this and that it is one huge stalling tactic. You're going, would I, would I, would I? I've been asking for years. And the judge ordered you, even though he didn't actually do it, he ordered you to give me everything I want, my hymnal, my coffee, my food. Until my unknown, undetermined criminal case. That's why it just so happened to get continued 16 times. And throughout those 16 continuances, she still didn't get what she wanted for Brian, and she still tried to delay further and further. It's a mess. Your relief would be sought if you just did what I said. Translation, I'm an abuser who will beat you down until you give me what I want. And then we'll be shocked when they take that away. And I've let these cases play out because half of this sounds just like some Chat GPT mess. Like, the fact that they are struggling this hard to find these cases is embarrassing.
Are you ashamed of yourself? Are you not embarrassed? This is really embarrassing.
And it's like you just took sound bites from the cases. It just shows that you didn't actually read the opinions, that you were just looking for sentences. And that one sentence, what was it, I think it was the Hunter case or something, saying disparaging comments constitutes harm to the child and this and that. Basically everything she's been saying verbatim that is hyper specific to her situation. Of course, that case covered that specific topic using that specific phrasing that just so happens to be the phrasing she's been using this entire time. And also, we can't seem to find the case. And then when she finally does get cases in there, they're for the most basic and blandest points ever that no one's fighting you on. And then all these other cases are very minimal points that don't actually lend itself to her situation whatsoever, and only unravels that. She's given so many cases that goes against her own arguments. Every time she says, this can only be limited in the best interest of the child. Yes, it has been documented and testified to, and evidence have been shown that you are detrimental to that child's well-being when you have no limits and you have no proof to the contrary. You keep doing this second person hearsay of, he apologizes to me all the time, he says his father's this, he says his father's that. You're just using him in reverse. You're saying he talks disparagingly about his father to you all the time. That just so happens to be something that you remembered so that you can use it in these hearings as a weapon. And it just so happens that your son's not here to corroborate any of this. But you're going to say that you wish he was here so that he could confirm all of the lies she's been pushing because she thinks she has such a manipulative stranglehold over him. And when they're in one-on-one conversations, he may be more passive and gives in to the antics of just, this is me getting through the phone call. And Sarah, because she's done this with everyone, she thinks she's actually good at manipulating people, which then backfires on her every single time.
See, and then it's all backfired on me. Like, it's all backfired on me. And I understand the severity of this.
Yeah, you did.
It's awful, I know.
Okay.
It's awful. And I will tell you both this right now, too.
So she would be absolutely befuddled and shocked when if the son got on the stand, which she would have forced him to do in order for him to be involved, forcing the child to be sworn under oath to give testimony just so that you feel better and make a few points, still not supporting your argument of why you need alimony and shared parental responsibility. Brian argues that you make terrible decisions, and that would be a terrible decision. You just have a track record. You leave people in suitcases thinking they're going to survive. You zip your son in a suitcase thinking there's nothing wrong with it, so much so that you post about it on Facebook, and it's so funny to you that other concerned parents had to actually call CPS on your ass. It's a never-ending string of terrible decisions. It's just the confidence that she says all of her ludicrous claims. It's so conflicting to all the evidence that surrounds her that it's almost impressive and makes you second guess, well, am I being too critical? Am I the crazy one? No, this is absolutely absurd. Someone who killed someone and has been convicted to a lifetime sentence in prison for said murder has no right, room, or space to make any of these demands. This is a mess. Yeah, I'm gonna keep trying to let it play as much as I can because this case law debacle is a nightmare.
That's correct.
Speck v. Speck, S-P-E-C-K. The citation is 225 SO 3D 319 parentheses, SLA, 3D, DCA, 2017.
So it's Brown versus State?
Fact v. fact.
Okay, I need a citation one more time, I'm sorry.
Sure. 225 SO3D 319 parentheses SLA 3D
All right, the court is not finding a Feck versus Feck case. That is a citation for Brown versus State.
Are you not ashamed of yourself?
Which is a 2017 opinion regarding waiver of appeal arguments dealing with a sentencing order.
Okay, one moment, please. If I may. I'm looking through really quick.
Are you not embarrassed? This is really embarrassing.
Okay. I'm just trying to locate. Okay, Your Honor, forgive me, that's what I have for that one.
I'm sorry?
Okay. That's the 225, that's what I have for that.
This is really embarrassing.
Which apparently is
All right.
not right.
All right, any additional cases?
No, Your Honor.
All right,
For
all
that, no.
right. Any additional evidence you want the court to consider?
In regard to the parenting plan,
In regards to any of the issues that we're here on today that I have recited over and over, I think I might be on time number 7 now.
Yeah. Double homicide. Double homicide. Double homicide. Homicide.
Bitch.
No, I'm sorry.
in regard to alimony, I would like please to add case law.
Oh, Lord. Again.
No, God!
Fucking again. Nothing new, nothing
God,
changed,
please,
same old
no,
shit.
no,
Same old fucking shit.
No! No!
Okay.
Florida statute 61.14, I believe.
All right, repeat it for me, I'm sorry.
Just one moment, I'm trying to make sure that I have everything pulled up. Okay, I'm going to start, please. Would you like to have the citation?
Yes.
39 SO 3D 453 SLA 2D DCA 2010.
All right, is that Malik versus Malik?
Grigsby versus Grigsby.
Say the citation for me once again.
39 SO 3D 453
Okay, now say the name of the case for me.
Grigsby, Grigsby.
Got it.
Not have to do with alimony.
All right, the court has found Grisby versus Grisby at 39 Southern 3rd 453, which is a second DCA case from 2010 dealing with the issues on sole parental responsibility, reestablishing time sharing.
This, I believe, was in regards to alimony.
It is not regarding alimony. All right, give me just a minute. We're going to have to go off the record for just a minute. We're going to take like a 3 to 5 minute break.
Okay.
My laptop, because something happened about 4 or 5 months ago, it only charges with a specific charger. And so my computer is telling me it's about to die. So my judicial assistant is running up to grab a charger that's actually going to charge my laptop so it doesn't die. Okay?
No problem.
And I do apologize for that. But meanwhile, I am going to make sure I save my notes so that they don't disappear. If my computer should all of a sudden go completely out.
This is just so funny to me because this is another instance where someone's laptop or someone's recording device has gone out when working with Sarah. She just can't catch a break when it comes to losing lawyers or when it comes to faulty technology that once they come back, it just buries her.
No, I don't remember that.
For everything you've done to me. For everything you've done to me.
Your battery's about to die.
Shut it down.
Oh, okay.
This is because it did technically stop and I wasn't able to say the time that it stopped prior. We have not talked anything further, not on recording.
Correct.
Okay. And you do understand that you don't have to speak with me if you don't want to, correct?
Yes.
Okay, perfect.
Ms. Boone?
Yes, Your Honor, I'm here.
Okay, all right. I don't know if you were able to hear me earlier. Just so you know what's happening in the courtroom, I am in a different courtroom today. And even though my laptop has been plugged in to allow me to see on a separate screen, it was not charging due to an issue with my laptop that happened about 3 or 4 months ago. So now we have a charger for my laptop. I am back up and I am ready to take your next case citation regarding alimony.
Yes, Your Honor, thank you very much. My next is Bowen, B-O-W-E-N versus Bowen. And the citation 471 SO 2D 1274 SLA 1985.
All right, give me the number after the 2D.
1274.
Got it.
Parentheses.
Okay.
Okay.
All right, for counsel, I have the Bowen versus Bowen case, 471 Southern 2nd, 1214, Florida Supreme Court, 1985.
I've got it. Thank you.
All right, go ahead, Ms. Boone.
Arrearages and alimony are vested rights and enforceable. While the court-ordered alimony period has now ended, the expiration of that period does not erase arrears that accrued while the order was active. Florida law is clear that past due alimony becomes a vested right, and the obligor remains responsible for payment regardless of whether the alimony term has since expired.
All right, anything else?
Yes, I have, the citation is 418 SO2B 1113. It's Florida 5th DPA 1982.
What's the case name?
Lamb versus Lamb.
All right, that was 418.
SO2D 1113
418 Southern 2nd 213.
2D 1113. So 1113.
I'm not seeing that one. That site.
All right, give me the full site. Start with the first numbers again.
418.
418 SO2D
1113. In parentheses, Florida, 5th, 5th, DCA,
The court does not
1982.
find the Lamb case at this citation. 418 Southern 2nd, or do you say 2D or 3D?
2.
All right, that is not a citation for a case named Lamb.
Oh, Lambert.
All right, and I need you. How many more of these you have? We were down in 15 minutes, and I got to give counsel an opportunity to question you, and then save time for closing arguments.
I'm not sure. That's why being on the phone is very difficult. I'm sorry. I'm doing everything that I possibly can to properly represent myself.
Cute rehearsed line, but no, you aren't. You're doing your best to cause as much of a commotion as possible, trying to restate the same exact point 10 million times without ever making any ground, and just trying to find new ways to point the finger and put the blame on someone else. It's not my fault. It's the correctional facility, the clerk's office. They told me to lie on my financial affidavit. It's not my fault. It's Brian who forces me to use my son as a pawn. It's not my fault. I have to abuse the court system because they won't force my former husband, to pay money to me despite the fact I'm in prison. It's George's family's fault because they didn't stop him. It's George's fault because he died on her. It's everyone else's fault but hers. And it comes through in every single conversation or point she tries to make. Because now when the time has run down, she wants to point the finger. It's the telephone's fault. As though I'm just going to imagine there is a clock in the room that she's in. And if there isn't, maybe there's one on the phone. I just don't believe that there isn't. She could have managed her time better. She chose to go round and round and round and said, did you include me? Why are you only giving me a 30-minute phone call? Don't forget my arrearages. I want to be in my son's life. This is unfair. I shouldn't have to prove my worthiness. The petitioner is so evil and wrong, and this would all be fixed if he had just paid, or if he had just mediated, or if he had just had the meeting of attorneys and unrepresented parties. It's always something. And then has the audacity to say that everyone else points the finger at her when it's just, I don't know.
Sometimes I'll start a sentence, and I don't even know where it's going. I just find it along the way.
But this is her doing the best she can to properly represent herself, meaning I'm going to ceaselessly argue until you cut me off and I'm dragged out of the courtroom by my uniform while still trying to speak. Then I can say I represented myself properly. And if you don't side with me, it means you weren't listening. Unfortunately, we've been listening this whole time and you have said jack shit nothing. Truly, now reflecting back, she hasn't made a single argument for why she should have all of these things. She has only made arguments of complaint, asking for things, asking for punishments, and her only defense is that it was court ordered in 2018 when she was not contemplating any criminal charges, which I will push against that because that was the time she was arrested for a third-degree felony strangulation.
Hands behind your back. For what? For battery domestic? Me? Both of you. You two hitting each other. This is for real? This is for real. Why am I in trouble though? Because of the marks he has all on his neck and the inconsistencies of the story.
Why? Because I fucking fought back?
And Brian had to bail her out. So, I don't know how far along they were in this when they were agreeing to the settlement, but the warning signs were clear up front, and she lived up to everyone's fears and expectations.
They're gonna think I killed him. Why would they think that? They always have said that. They've always have said that.
Everyone fears that she was a bad influence on her child and the way that she neglected him and then love bombed him, and then that never-ending pendulum cycle of forcing your child to self-regulate you, as well as forcing George to self-regulate you and to self-fund you, also while abusing, berating, letting all of your internal anxieties and all your internal inadequacies, letting them loose on him to where he couldn't do anything right. He was always the abuser, thus you were always justified in doing anything you wanted to him at any moment. All of this to say, I am definitely rambling, but just no. Please, just stop. Stop this. Put an end to your suffering. None of this will help you.
Lamb is not Bowen versus Bowen. Tindall, Tindall.
All right, give me the citation.
It's not on here. Forgive me. They didn't give it to me.
They? Who's they? They didn't give it to you? Another person to blame? Would this be one of your contributors that doesn't exist? Whoever typed up your pretrial statement? Dang. Can't take responsibility for anything. I hope y'all heard that. All your hard work, y'all didn't give it to her. Then maybe you should only cite cases you've actually read. Could avoid a lot of whatever this is. Because also, like, even the cases you do cite that are accurate, as in they actually exist, not necessarily that they apply to the situation, those don't really matter less and less every single time you have been found to give a fake citation or an inaccurate citation, because it's like, oh, okay, you obviously just searched for anything you wanted to throw in there. Again, you don't take this process super seriously and want it to overwhelm with the number of cases and not the quality of the cases. But I digress.
All right, without a citation, the court cannot find a next case.
I'm sorry. My classifications department is speaking to me. Hold on one moment, please. I'm sorry.
Hello, excuse me. Your Honor.
Oh no, this is so cringe. Not the security guard or the prison guard, whoever, barging in. You're not sworn in. You're not anything. Why are you here? Yikes, this is not going to end well.
Hello, Your Honor.
Yes.
This is Classification Officer Santiago. I work at Lowell Correctional Institution. Due to our procedural operations over here, she's going to need to be off the phone at 4:50 in 5 minutes. And I just thought that I would come on here and let you know.
Your Honor,
and
may...
Then, and then
Okay.
also, for future court appearances, they are requesting that communications go through the classification officer so that we can make sure that these she has plenty of time to complete all of this so that we're not having to rush her off the phone.
That's probably the dumbest thing you could have said. They're in trial right now, and you are saying, and can you make sure next time that you contact us? Girl, if you don't go sit down somewhere, no. Not trying to get set. This is a literal trial. Your procedures can hold off for half a second. Yikes. But this is what happens. Sarah has wasted so much time. So much unnecessary time. Wow.
Right. Information was sent regarding this final hearing. And my office has been in contact with the Department of Corrections for quite some time over the last couple of months trying to get this set up, because we had initially requested that she be transported to Orlando for this hearing.
Oh, so they wanted to have her there in person the whole time. So she causing this big stink and blaming the court for not doing so was actually because the prison did not want to ship her ass over here. Nice.
So there has been contact. All right, but right now you are slowing us down and trying to get this finished. So give me just a minute. Hold on. Yes, counsel.
Your Honor, what I would suggest, I have no other questions for Ms. Boone. So what I would suggest is that perhaps the court allow both me and Ms. Boone to have a certain amount of days, not a super long amount of days, but a certain amount of days to provide written closing arguments to the court, and then the court can take the case under advisement and make a ruling, so we can get this done today.
All right. All right, so what the court is going to do is we're going to go ahead and finish up, I believe. Other than case law, Ms. Boone, did you have any other evidence that you wanted the court to consider?
Yes, I did. I had some other exhibits that I would like to have put into my evidence, and then I also was supposed to speak about the attorney's fees.
Then why didn't you do that? You have been sitting here for hours and hours and hours saying, I don't want one 30-minute phone call. I have so much to offer. I am my son's only mother. Brian doesn't include me. He says he doesn't care. He's so mean. I need my money, this and that. You have had nothing but hours to get through stuff. And now that you're about to get dragged out of the courtroom by your uniform while still trying to speak.
Said order being ordered and me being pulled by my uniform to exit your courtroom while still trying to speak. She was pulled from the courtroom by her uniform.
Now you can rattle off exactly what you need to talk about. Well, I had all these exhibits to get in, and then I had to talk about attorney's fees. You already talked about it. Is having an attorney a choice? You would have just said the same thing again and again. But now you have urgency. Now you want things to go in. Of course. Of course you do.
I've given you lots of time to speak about all the issues. The fact that you didn't take that opportunity instead of going into other issues is not what the court is going to address now. What specific exhibits do you would like to move into evidence?
Your Honor, forgive me, but I'm here on the phone trying to do all of this.
When I ask you what other exhibits that you want to put into evidence.
Yeah. Double homicide.
Oh, Miss Jackson.
Miss Jackson. Ooh, I am real.
Has had it. Wow, that is incredible. Because that's what she does. She always tries to, well, it's not my fault, it's this. Well, excuse me, I'm on the telephone. Excuse me. Tell me if you have any other useless exhibits to enter. Let's speak now or forever hold your peace. But here's the thing. Sarah always backs down to women. So as soon as a woman pipes up with her, she gets real submissive and moves right along. Yeah, it can't be any clearer how bad you lost this.
My number 10. Respondents, correspondence. I'm sorry. Number 9, respondents. Motion for contempt.
All right, I'm not considering a motion for contempt with regard to a final hearing. Okay? Anything else?
It was my understanding it was held in continuance until this actual moment, which is why it's been waiting to be heard.
I think she's referencing, Your Honor, the motion for contempt on the non-payment of alimony, not the most recent motion for contempt that she filed.
Okay.
Yes,
Yeah.
this was done,
The court
and
will take judicial notice that you have filed a motion for contempt with regard to the alimony. Okay? And that is
was back in
something that
2023.
that is something that I am considering because I've got to deal with what the alimony that was not paid, okay?
Yes, Your
All
Honor.
right, so with that clarification from counsel, I will take judicial notice of your motion for contempt with regard to the alimony.
Okay. And then also the petitioner's account statements, which is my number 15.
Counsel, this looks like Truist bank statements.
Okay. No objection, Your Honor.
All right, hearing no objection, I receive into evidence what was pre-marked as 15 as Respondent's Exhibit number 6.
Yes, Your Honor. And then number 21 through 25. Respondents, correspondence to judge regarding non-payment of alimony, parental alienation, and requests for case management conferences.
Very good. All right. These are filings within the court. The court does not need to receive this as evidence.
Okay, if I may ask for judicial notice.
All right, the court will take judicial notice of documents that were filed on October 18th, 2022. January 31st, 2023.
There should be 5.
February 22nd, 2023. I do not see a filing date with regard to number 21.
They should be 2022 through 2023.
For the record, counsel, Exhibit 20 is a notice of filing prepared by yourself. Looks like, again, filing some documents that you received. I think, oh no, this is notice for trial for 20. All right.
I'm going through it as well.
All right, so also court's going to take judicial notice of the notice for trial filed on, August 17th.
That's not part of my evidence. You may have gone one too far.
You just told me 21 through 23. All right, so that's 20, so we don't need that one. All right.
21 is respondents. 22 is
All right.
respondents.
Exhibit number 24 is not indicating that I don't see anything on it that it was filed with the court, but it is a.
It was probably cut off from the copies that I had to obtain.
All right, the court does not need to take judicial notice of a request for case management conference, so the court will not take judicial notice. Anything else?
It's trying to show my exclusion in the case.
Oh my gosh, move on. Like literally, this has literally given me a migraine, so I'm sorry I'm running out of commentary because I can't even think straight anymore. This is insane. All of these points are useless. She's made them before and they fell flat. This is my exclusion in the case. So how is a request for a case management showing? It's all self-serving hearsay. They've said it a million times. Self-serving hearsay is when you are trying to use out-of-court statements and use them as though they are facts that were testified to in court. You don't need to show letters that you sent because you can just testify to it. And that testimony outweighs any written document you could provide that says those words that you testified to. Oh my goodness. Well, I hope we're almost done.
The court has ruled I am not taking judicial notice of a request for a case management conference. Anything else?
Number 27, 28, and 29.
All right, 27, it looks like it's a letter dated March 2nd of 2023 to Attorney Martell. Any objection to this?
If it's a letter to me, it's self-serving hearsay, so I would object.
All right, I'm going to sustain the objection as to exhibit number 27. I have a November 26, 2024 letter addressed to Attorney Joshua Martell as exhibit 28. Any objection?
Same objection, Your Honor.
Sustained. Number 29. appears to be handwritten letter to Brian dated May 12th of 2024, marked as exhibit number 29.
Same objection, Your Honor.
All right, sustained. All right, anything else?
Number 31. Respondents, witnesses, letter.
So letter to whom it may concern.
These are my character witness letters.
Character witness letters? What do you mean? This isn't criminal court. You're not at sentencing and you have character witness letters where they are trying to say, hey, don't give her life in prison because she's actually not that terrible of a person. You think there are character witness letters for you getting alimony and having more than 30-minute phone call with your son? Oh my goodness. The plot has been completely missed here.
It's your what letter? I'm sorry.
Character witness letters.
Objection hearsay.
Sustained. Next.
Number 32.
Number 32. Current judgment interest rates.
Those are in regards to alimony arrears.
If it's just reciting the statutory interest rates, no objection, Your Honor.
You review the document.
Let me see.
You object or you don't. Deputy, you could hand him this.
I haven't seen any of these exhibits, Your Honor. My apologies. No objection.
All right, hearing no objection, I receive into evidence what was pre-marked as 32 as respondents exhibit number 7. All right. Anything else?
Number 35 and number 37. They're telling me I have to go.
All right. Number 35. You can approach counsel.
Okay, thank you.
Looks like something dealing with the canteen.
It's the canteen items with current pricing. That's for snacks for medical reasons.
Security heavy.
That's for snacks for medical reasons.
All right, hearing no objection, I receive into evidence what was marked as number 35 as number 8 and what was marked as number 37 as respondents number 9.
The JPay communication features and current pricing.
All right, next.
The number 37, which is JPay communication features.
We already admitted that into evidence as exhibit number 9. Next.
Okay. And you have the GCL communication?
Oh my gosh, will you ever stop? I literally had to go lay down to finish this video. I've had to relax myself as much as possible just to make it through. They have all of the whatever communication prices that don't make any lick a difference. You had nothing but time to introduce all of these things, and you decided to hurl insults and accusations instead of literally introducing the evidence that the judge is going to consider.
I have no idea what that is. If you next piece of evidence that you want to, next exhibit that you want to admit into evidence. Anything else?
I think we're missing one because I'm going to put in the JPay communication. I put in the GCL communication, but not the JPay.
We have number 35 admitted into evidence as number 8. Number 37 admitted into evidence as number 9. Next.
Number 36.
I can look at this, Your Honor.
You can stay up. All right, we're receiving into evidence what was pre-marked as 36 as respondents exhibit number 10. Which is also
Yes,
a J letter. Next.
That's all I have for right now, Your Honor. I'm being rushed out.
All right, I'm going to give you all until next Monday at 5. I'm going to say by 5 p.m. That includes, Ms. Boone, you need to put it in the mail by next Monday, a written closing argument on the issues we're here on today. Okay? So I'm going to give you all until 1 week to provide written closing arguments, no more than 5 pages.
No more than 5 pages?
That is correct.
Parenting plan, alimony, attorney's fees.
Counsel.
Can I submit real quick 2 exhibits before we end?
All right, what are they?
I just have, these are more for demonstrative purposes, but I have my proposed child support guidelines worksheet that was marked for identification purposes as petitioner's B, and then my case law, which is in hard copy form marked for identification purposes as exhibit C. This is all.
Or what was the child support guidelines? What was it pre-marked as?
B.
B as in boy, and then the case law as C.
C.
All right. Ms. Boone, do you have any objection to what was pre-marked as petitioner's exhibit B or C, the child support guidelines or case law?
No, if someone explains it to me though, if we have a chance to, I don't understand it.
All right. Hearing no objection, I'll receive into evidence what was pre-marked as B as petitioner's number 4 and what was pre-marked as C as petitioner's number 5.
Please, if I may, before we hang up, the closing arguments are for parenting plan, alimony, attorney's fees, and...
I am not repeating myself, ma'am. You need to make a closing statement. You need to put it in the mail to me no later than next Monday, which I believe, actually, that's a holiday. So I'm going to give you all till Tuesday, which is September 2nd. I will not accept anything that is postmarked beyond September 2nd. Again, this is closing arguments on the issues we're here on in trial today. No more than 5 pages. Thank you and have a great day.
Court dismissed. Bring in the dancing lobsters.
And that is going to be it for this little segment. Again, I say little, we're at 3 hours and 40 minutes, but this truncated section of the 9-hour video, director's cut edition, I hope you enjoyed this. We are still on order watch at the time of posting. We still do not have a final decision from Judge Jackson.
Miss Jackson. Ooh, I am for real.
There could be a million different reasons why it's taking this long, but I know we are all anxious to finally find out if or how free Brian and his son will be from this. Okay, it's the end of the video. I'm going to be kind. Human being. But if you did enjoy the video, remember to like, comment, subscribe, dislike if you're feeling it. Until next time.